Says leave meeting, got it. That's and then
Acting Chief Justice.
Can be, they're just fixing my screen. Okay.
If a block has come, got it or leave meeting, if they can just click on got it, please, Acting Chief Justice.
Yeah, I just picked it up right now. Yeah. Okay, all right. Can you let?
Is Justice Rogers with us? Oh,
sorry, I somehow gone off it.
Is, yeah. Okay, all right. Zunaid.
With your leave, Acting Chief Justice, can I ask the clerk registrar to call the case?
Yes. Doing that. Please, the clerk to do that. Who is calling the case? Who is calling the case?
May we ask our colleague
Yes.
Owen to read?
Ms. Khoza,
where
Ms.
is
Khoza
she?
with us?
Can she hear us?
I'm about to admit her now, Acting Chief Justice.
Oh, was she not there?
She was not online. I'm sorry about that. I hadn't noticed that.
Oh.
Acting Chief Justice, through you, may we ask our colleague Justice Rogers to rename himself, please?
Oh, what has he got? Yes.
I'm able. I will do that. I will do that.
Will you do that for him? Okay.
It's done.
All right, it's done. Yeah. Yeah. Okay. Is the clerk there to call the case?
Ms. Khoza, are you with us?
Yes, I am, Justices.
Please, can you call the case, Ms. Khoza?
Call the case.
Good morning, everyone. I am the Registrar Clerk for this hearing. Acting Chief Justice and Justices of the Constitutional Court, all counsel are online. I call the matter of NVM on behalf of VKM and Tembisa Hospital and another for hearing. Counsel are now invited to place themselves on record. Please note that this hearing is being recorded.
Thank you.
As it pleases the court, Acting Chief Justice, I appear for the applicant in this matter together with my learned friend, Ms. Weber.
Thank you, Mr. Butlander.
Acting Chief Justice, Ms. Mofokeng, and I appear for the respondents.
Thank you. Thank you very much. Yes. Mr. Butlander.
Thank you very much, Acting Chief Justice. Acting Chief Justice, members of the court, as the court knows, this case arises from a delictual claim brought in the Johannesburg High Court, where it succeeded on the merits and which ultimately went to the full bench where it was overturned. We are going to submit with respect that the full bench erred in two fundamental respects, both of which require this court's attention. The first is that the full bench erred in effectively transposing or relying on factual findings of the majority of the SCA in M versus MEC. And we're going to submit that that was inherently impermissible and that it's clear that that was at the heart of some of the full bench's reasoning. Second, we're going to submit that the full bench erred in the test that it applied in relation to causation. Because as this court knows, and I'll come to the volte-face by the respondent in a moment, but as this court knows, before Judge Keatley and before the full bench, negligence was not an issue. It was conceded. The only issue was causation. And in relation to causation, what the full bench did is it effectively preferred the traditional test for negligence, which had been adopted in M versus MEC by the SCA, and the majority in that SCA decision, and did not apply or even seek to apply the more flexible test for negligence, which emerges from this court's judgment in Lee. Now, I want to be clear, if I may, Acting Chief Justice. We say that whether you're under the traditional test or the Lee test, the case succeeds. But our submission is that if the traditional test did not suffice for a finding of liability, then at the very least there had to be a grappling with the Lee test, and there was none of that from the full bench. So those are the two fundamental errors we submit that the full bench made, and both of them require the attention of this court for the reasons I will come to. My junior has WhatsApped me to say, I keep saying negligence instead of causation, but I'm sure the court picked it up. Of course, what was it? The value of a good junior is she points out when you make mistakes, and you hope that she doesn't have to do so too often. But the point is, of course, negligence was not at issue, causation was at issue, and Lee relates to causation. And that's the point. I'm very grateful for that pickup. So that is where we submit that the full bench erred. What then happens in this court is really a volte-face, because it is interesting that our learned friends for the MEC and their new team don't really seek to defend the full bench's reasoning in its own terms. What they seek to do is really make a series of new propositions, and they seek really to reinvent the case. Firstly, they seek to say that negligence is no longer conceded, and they will have to explain on what basis that shift is done. But secondly, they now seek to suggest that on the facts, in fact, it was impossible for this to have made any difference, because what they say is a series of three propositions. The first proposition they say is that the brain damage occurs 10 to 30 minutes from the sentinel event occurring. We say that's wrong. That's not what the evidence demonstrates. The second thing they say is that the sentinel event occurred at 4:40. 20 to 5. Well, we say that's also wrong. That's not what the evidence says, and it was never put to any of the witnesses that that is what occurred. And then the third point they make is that it would take 30 minutes in order for the cesarean to be arranged. Well, we accept that, but we don't accept the first two propositions, and once that's so, then the third proposition doesn't really go anywhere. So we submit with respect that the full bench approach cannot stand, and the approach of our learned friends to try and repair the damage cannot stand, and therefore the appeal should succeed. Could I turn to deal with those points, but just say one word about jurisdiction and condemnation, if I may, Justice Zondo?
Yes.
On condemnation, I understand that condemnation is not opposed for the late filing of the application for leave to appeal. On the question of jurisdiction, it seems with respect obvious to us that the court has jurisdiction, and really one needs to do little more than read this court's judgment in Mashongwa versus Prasa, where this court explained that where a delictual claim is underpinned by constitutional rights and the state's duty to take reasonable measures, or its duty under 7.2, then it follows that this court has jurisdiction. And we submit that precisely the same applies here. If I could just commend to the court in that regard the judgment of this court in Mashongwa at paragraph 13. So we say the constitutional issues jurisdiction is satisfied, but even if it were not, these are points of law of general public importance. With that out of the way, Acting Chief Justice, could I proceed to deal with the merits? And could I say, if I have any time left of my 10 minutes, I will happily give it up with that introduction having been given.
Okay, no, that's you still had 5 minutes, so that's fine.
Excellent.
Is it correct, Mr. Butland, to say the real issues really relate to what happened between 3:15 in the morning and 4:45, I think it is.
Yes.
During that
yes.
1.5 hours.
Yes, that's.
And the experts agreed that there was no monitoring that should have happened during that period. And it's common cause that at 4:45, that's when it was discovered that a cesarean section should be undertaken.
Yes.
But it seems that by that time, there would not have been enough time to have it done.
Yes.
So what remains is therefore the question of when did the situation arise which ought to have been picked up if the necessary monitoring had happened.
Yes,
and did that event arise at a time when there would have been enough time for a cesarean section? But when I say that, it seems to me, and you will be able to indicate if my understanding is wrong, it seems to me that it's not a question of simply saying a cesarean section, whether a cesarean section could have been done or not. There are other, I think they were referred to as preparatory measures that, according to the experts, I think Professor Dr. Pistorius or Kirsten, one of them, Pistorius, I think it was, who said various measures could have been taken that could have bought time, as it were. And the question then would arise, if those were taken, is the position that there would have been enough time for a cesarean section if the monitoring had happened and this was picked up and they were taken? Could that have provided enough time? That's my understanding of where the real issues are. Of course, I struggled to find in the judgment of the full bench an engagement with what Professor Dr. Pistorius called preparatory measures. It seems that if my understanding of the judgment is correct, that the full bench may have simply focused on whether there was enough time for a cesarean section to be undertaken. But even then, the full bench seems to have simply looked at 4:45 and not starting earlier. So there is that part which I would like you to deal with. Of course, there is the evidence, and I think Mr. Brainders refers to it, and maybe it's one of those matters which you say they are coming up with for the first time. There is the issue that they raise, namely that the event that happened would have been a sudden event that would not have been picked up even if there was monitoring. So I would like you to deal with both scenarios, because as I understand, they are saying, the expert evidence says this injury was caused by an event that would have happened as an emergency or something sudden. Even if there was monitoring, it could not have been picked up and nothing could have been done about it. So you can just indicate whether my understanding of this part of the matter is correct and deal with those two.
Thank you very much, Acting Chief Justice. Your understanding with respect is absolutely correct, and with respect, the way you've put it is very helpful. Could I use your question to explain what did happen, what didn't happen, and the correct position?
Yes.
You're quite correct with respect that the question is what happened between 3:15 in the morning and 4:45 in the morning. That is the critical question. And we know two things. The first is we know what did happen. It's common cause that what did happen during that period, and we don't know precisely when, but we know during that period there was the Sentinel event. We know that.
Yes.
We also know what didn't happen during that period. And what didn't happen was the monitoring of the fetal heart rate as was required by the Department of Health's own guidelines. And it's common cause that between 3:15 and 4:45, there was no monitoring, and there was meant to be monitoring every 30 minutes. So we know what did happen. and we know what didn't happen. What we don't know is the precise moment between 3:15 and 4:45 at which the sentinel event occurred. And there's a reason that we don't know. The reason that we don't know is because the monitoring of the fetal heart rate didn't occur. If the monitoring of the fetal heart rate had occurred, as was required by the guidelines and as used to be common cause was what was required of a reasonable clinic, we would have known when the sentinel event occurred with a greater degree of accuracy because we would have been able to pinpoint it to within half an hour. But we don't know that because of the very negligence which is sued on in this case. So in essence, we're in a very peculiar situation where the respondent seeks to say you don't know when it occurred and therefore you haven't proved causation. But the reason we don't know is because of the very negligence at issue. And in other words, it's their failure which produces it. So with respect, you are quite right on that first point. On your second point, in relation to the question of buying time, you are also quite right. And with respect, the error of failing to understand what you've called preparatory measures or what I call buy time, it's the same concept, it permeates both the full bench judgment and our learned friends argument. Because what our learned friends do is they say, well, it's the evidence of Kirsten in his report is that brain damage occurs 10 to 30 minutes after the sentinel event. But what they do, and I think I should deal with it immediately, what they do is they confuse two things. There are really three stages, and I'll take you to the evidence in a moment. The first step is when the unidentified sentinel event occurs. Now, when that unidentified sentinel event occurs, it causes warning signs. And I'll take you to what those are. But in essence, the warning signs are the heart rates that are reflected on the fetal monitoring. Because what happens is that the heart rate doesn't recover as quickly as it ought to. And so what you see is that warning sign, and the response to the warning sign is what you've called the preparatory measures, which buys the time. At that point, the injury hasn't yet occurred. We've just had the sentinel event, but we haven't had the injury. The second step, which occurs after these warning signs, is the injury. And the injury is what is actually called the fetal bradycardia. That is not just when the heart rate is irregular or drops and raises or doesn't respond after contractions as much as it should. It's when it drops below 110 and stays below 110. That is the fetal bradycardia. That is the injury. And then the third thing, and this is what occurs between 10 to 30 minutes later after the injury, is the brain damage. So you have these three steps. The first step is the sentinel event. The second step is the injury. And the third step is the brain damage. And what our learned friends do in their attempt to reconstruct or revise their case is they collapse the first two. They think that the sentinel event is the same as the injury, and they therefore say, well, any warning signs would have happened between that 10 to 30 minute period, and so therefore there wouldn't have been enough time. But that is wrong with respect, and it is not what the evidence shows. Could I've of course have simplified the evidence in explaining it to you because much to my grandmother's disappointment, I'm a lawyer, not a doctor, and I have therefore had to simplify it somewhat. But what I've done is really summarize the evidence that was given by Dr. Kirsten, Professor Kirsten. And perhaps I could just take you there because it is very important given the centrality of this.
Yes.
If the court was to go to volume 2, page 133, you will see at the top of the page, there's a reference to the fact that Victor had acute, profound hypoxial insult. It's all helpful to be read in context. But if I could then skip a few lines down, it says, during labor, the point is made, it's difficult to pinpoint when it starts. During labor, it's not that easy. And that is where fetal heart rate monitoring and fetal frequent observations are so important, because it will give you an indication that climbing up the onset, in other words, it will give you the warning signs. And then the duration of the actual final bradycardia varies. And it depends on if there is a total loss of oxygen provided to the fetus. Can I just pause there? Those are the first two steps. The first one is the fetal heart rate monitoring. That's where the warning signs. And then he refers to the actual final bradycardia. That is what I've called the second stage, the injury, and the actual fetal bradycardia. That's the 10 to 30 minutes. And then he speaks about if there is an abruption. Now, of course, we're not dealing with an abruption. That's where the placenta comes away and the court intervenes. And he says, well, if there's a total complete abruptio, the court will have, the lady will have signs of a cardio. It's the same with strangulation. There's no separation. And then he says, I'm now at line 15. In other situations where the cause for the acute profound hypoxia is not clear cut. So that's what we're dealing with, the undefined sentinel event. He then says, in those situations, the fetal bradycardia can last for 30 minutes, but that is the fetal bradycardia, the slow heart rate. If there is hypoxia, the heart rate requires muscles. So the final sign will be that the fetus will have a very slow heart rate. But before the onset of that slow fetal heart rate, the fetus from the CTG, that's the fetal cardiogram, will have the changes in the pattern of the CTG. I do not want to get into that because I'm not an obstetrician, but it will give you warning signs that, or the fetus will pass meconium as a warning sign. There is something going on here, but the final end of the hypoxia, the baby, the fetus will have a very slow heart rate, and if he's not delivered, he will die in utero. So what he is distinguishing between very clearly is the actual, he calls it fetal bradycardia, which is my second step, and that lasts for up to 30 minutes. And the things that occur before the actual fetal bradycardia, which is the sentinel event, which causes the warning signs to start. And so what is clear from this evidence, which was not controverted because there was no countervailing evidence and it was not taken issue with in cross-examination, what is clear is that the warning signs precede the actual fetal bradycardia. And the actual fetal bradycardia is what takes 30 minutes. So the buying of the time with respect, Acting Chief Justice, occurs before the actual fetal bradycardia occurs. And that was the evidence of both Kirsten and Pistorius. And it's notable that they were never challenged on that score. There was cross-examination on other issues, but they were never challenged on that score. And so, yes, Justice Taran.
I'm sorry to interrupt you. Is there a point you'd like to finish first?
No, that's a convenient time. Thank you.
Well, please can you refer to paragraph 22 of volume 9? It follows on from your last submission about the evidence of Professor Kirsten and Dr. Pistorius. It's
yes.
Page 902.
That's the first of the paragraphs 22. I think there are two of them.
Yes. The second.
The second, yes.
Yes.
Thank you, I have it.
Yes, that's where the point that you've made a minute ago is captured about the uncontradicted evidence of Professor Kirsten and Dr. Pistorius. But that is not actually what I want to ask you. If you look at the last sentence.
Yes.
Or let's go a sentence before that. The last, about the 5 lines from the foot of that paragraph. From the expert testimony, it is evident that had the hospital staff properly monitored V's fetal heart rate in the critical period, it is probable that they would have picked up the warning signs that something was amiss. It is further probable that with the proper emergency measures, V's brain injury would not have occurred.
Yes.
Is that the right test? Would not have occurred, or should it be? Do we need more than that?
As I understand,
perhaps, sorry, before you answer, and if we have to read that with Dr. Pistorius's evidence at page 135 of volume 2.
Volume 2, page 35.
Page 135, Acting Chief Justice, volume 2.
Okay, thank you.
No, it's not 135. Sorry, I don't have the right reference. But perhaps I can read it to you.
Yes, of course.
Yeah.
Yeah, it's Dr. Pistorius's evidence. And he says if it is possible to start with resuscitation and deliver the fetus, expedite the delivery, you can hopefully prevent hypoxial brain damage. Sometimes not completely, but at least you can make a difference in the long-term neurodevelopment outcome. Then it's indistinct and maybe. Dr. Pistorius's evidence appears to have been that it was possible that emergency measures would have diminished or averted V's injury. But nowhere does he say that this was probable. And that's what the trial court found in paragraph 22 that I referred you to. Now, if that is correct, if that's what the evidence says, how can we sustain the trial court's conclusion that it is probable that with emergency measures, V's brain injury would not have occurred?
Yes, could I just give you...
I'm sorry, before you respond, Mr. Butlander, please don't forget the question. I just want to indicate the reference because Justice Leon said she couldn't find it. At page 135, it seems to be from line 20 to the end of the page. Yes,
yes,
that
indeed.
Is of volume 2.
Yes, it's Professor Kirsten, not Dr. Pistorius, but the quote that Justice Theron read me was indeed at that page. Yes,
okay, all right. You may proceed, Mr. Butler.
Thank you, Acting Chief Justice.
Justice Theron, I accept that the statement at the foot of paragraph 22 of the High Court's judgment is probably overstated because it finds that it is probable that the brain injury, well, let me read it more carefully, because what she says, the judge says, is from the expert testimony, it's evidence that had the hospital staff properly monitored V's fetal heart rate in the critical period, it is probable that they would have picked up the warning signs that something was amiss. So I think that, with respect, is consistent with the evidence. But then the second sentence says, it is further probable that with the proper emergency measures, V's brain injury would not have occurred. Now, that I agree is overstating it somewhat. It's more accurate to say that would have allowed the measures to buy time to take place. And that in turn would have allowed the delivery of the fetus in an expedited fashion. I'm now reading from Kirsten, from the passage, which would hopefully prevent brain damage, if not completely, at least make a difference in the long-term neurodevelopment outcome. So I accept that the last sentence of paragraph 22 overstates it somewhat and misses a step. But I submit that it doesn't matter for purposes of the appeal, because when you are on the order, I mean, it matters for the reasoning, of course, because when you have a look at that very passage of Professor Kirsten, it is clear that what he is saying is that if you get the warning signs, it is then possible to take the steps to buy time, to expedite the delivery, and hopefully prevent hypoxial brain damage. And even if you can't prevent it, you can at least reduce it. And that, in my submission, is sufficient for liability to result in this case.
Now, to the extent that the applicant relies on Lee,
yes,
is it not the case that Lee ought to apply only in circumstances where it is impossible or nearly impossible to establish causation using the but-for test, and not simply where it is difficult to do so?
Well, let me say this, if I may. The first answer is we say we don't need to rely on Lee. We say on the ordinary test and on applying the common sense approach to factual causation that this court explained in Oppelt and that we've put in our heads, it's good enough. But if there is a need to go to Lee, we submit that Lee would perfectly appropriately apply to a case where the reason that one cannot establish the but-for test with certainty, or, well, certainty has never been required, but where one cannot establish it with a sufficient degree of confidence is because of the very negligence that is at issue. In other words, where the state engages in a negligent failure not to do the heart rate monitoring, and that negligent failure is the reason that we don't know precisely when the event occurred, then it doesn't lie in the state's mouth to say, well, you haven't come home on the but-for test, because it's the state's own negligent failure that has produced that difficulty. So it seems...
Is that common cause, Mr. Butlander, that it's the failure to monitor that leads to the difficulty that the applicant faces?
Well, I don't know whether it's common cause. I'll hear from my learned friend, but my submission is that it's plainly correct. Because if the position was that it had been monitored every 30 minutes, we would know to within a 30-minute window when the event occurred, and we would know what could or could not have been done. The reason that there is uncertainty, if there is uncertainty, is because nothing was done for a period of an hour and a half. And so one is unable to know exactly when the sentinel event occurred. So I don't know whether it's common cause, but my submission is that it's correct.
I couldn't find anywhere in the record where the experts were asked whether emergency measures would probably have prevented V from sustaining his brain injury.
I accept that, and I'll be corrected by my junior in due course, and I'll give it to you if I'm wrong, but I accept that there was nothing squarely put to them on that. But what was put to them repeatedly is, what does one do when one sees when one has the proper monitoring and one sees the problem? And the answer given consistently by Professor Kirsten and Dr. Pistorius is one then proceeds to engage in the measures to buy time, and the measures to buy time then allow you to expedite delivery in a way that either prevents or reduces the brain damage. And of course, we're dealing here with probabilities. So and that was the point I was going to make. We do not have to establish as a certainty that brain damage would have been prevented. We have to establish on the probabilities that brain damage would have been prevented or would have been reduced. And I submit that on the basis of the evidence, that is the case, because where the experts testify that in general, this is the way it occurs, then if the respondent contended that this case was somehow different, that there was something in this case that somehow meant that that ordinary approach wouldn't have applied or benefited the child, then it was for them to adduce that evidence via cross-examination or their own evidence, and they didn't do so. And so on the probabilities, that the general techniques and the general evidence and tendencies is sufficient, I submit, to satisfy causation.
My last question on this aspect, Mr. Butlander, the failure, if we can call it that, of the plaintiff to ask the question or lead the experts about whether emergency measures would probably have prevented the baby from sustaining brain injury. Can the applicant therefore maintain, or can it be argued on behalf of the applicant, that this is a case in which it is impossible to establish causation using a but-for test?
Justice Turon, I don't want to say that it's impossible. Well, I don't want to say that it's impossible, but what is clear in my submission is that irrespective of whether the question was put or otherwise, it is clear that the only reason for the difficulty is the uncertainty created by the absence of the monitoring every half an hour. Because it's that everyone seems to accept, even the respondents seem to accept, that if a sentinel event is caught sufficiently quickly, then it is possible to prevent it. It's not their case that it's impossible in all cases. And of course, as Justice Keatley put it, if it were impossible in all cases, then what is the point of the monitoring? Why is it that we have these guidelines of heart rate monitoring every 30 minutes? But it's not their case that it's impossible in general. Their case seems to be either we don't know when it occurred, and that's a problem of the lack of monitoring, or that we know when it occurred at 4:40, and I'll come to that in a moment. But their main case before now seemed to be we don't know when it occurred, and therefore you haven't established it. With respect, that's not enough, because it's their own negligent conduct, their own conceded negligent conduct that produces that problem.
Mr. Butlander, I would like to raise two aspects with you along this line. And the first is more or less along the lines that my brother presiding the ACJ had asked you in the beginning, and the second one is the joint minute between Doctors Pistorius and Cole, on which much emphasis has been placed, paragraph 7. But that'll come later. First, as I understand it, negligence was conceded, and we'll hear what Mr. Brenda says about it later. And so I'm going to confine myself to causation on the basis that there had been no monitoring from about 3:15 to about 4:45. Now, the case that the respondents make out in their papers, and I must say, as far as I'm concerned, I tend to agree with you that it's a case that doesn't resemble the case that was presented in the High Court and before the full court. And the case is this: they say, and I want to hear you on the chronology of events. They say that according to Professor Kirsten's evidence read with his report, supplementary report, the brain damage would occur 10 to 30 minutes from the time of the insult, of the injury, of the sentinel event. And therefore, there was not enough time. Even if you were able to buy time, there wouldn't have been enough time to prevent brain damage, because you couldn't have done a C-section in time. Now, that is my first question that I'd like to raise with you. You say that that timeline that they present conflates these three stages. Do I understand you correctly there?
Yes, with respect. That's
that 10 to 30 minutes runs from which stage, do you say?
That 10 to 30 minutes runs from what I've called the second stage, the injury. It runs from the commencement of the fetal bradycardia, or what was called by Kirsten the fetal bradycardia proper. In other words, that's when it runs from.
Now, that is the stage when we know that occurs when you read the CTG, and there's high deceleration to below 110, and the heart is then supposed to accelerate back up to 110 within a certain time.
Yes.
If it doesn't, then you know you've got problems, and that is when the fetal bradycardia ensue, when the deceleration ensues below 110 beats per minute for a substantial period of time that you would pick up on the CTG if you are monitoring the CTG.
Yes.
Do you understand that correctly?
That's absolutely right.
Now, if then that 10 to 30 minutes runs from the time of the fetal bradycardia, we just don't know in this case when it happened because there was no monitoring.
That's absolutely right with respect.
And I just want to draw this to its logical conclusion. If there had been proper monitoring in terms of the maternity guidelines, then that would have been picked up, and there would have been ample time, you say, to make preparatory measures, turn the mother on her left side, and then start preparing theatre for the C-section. Is that what your case is?
Absolutely. You turn the mother on the left side, you try to slow or stop the contractions, you give her oxygen, exactly, and you allow time for the C-section.
Now, here's the question on the first part. The respondents say that even if there had been proper monitoring in terms of the maternity guidelines, the next one would have been, I think they stopped monitoring at 3:15, because then there was still evidence of maternal well-being and of fetal well-being because the amniotic fluid was clear and so on. They say that even if they had been monitoring then at 3:45, that would not have helped the plaintiff, because that would have been too late.
Yes.
And your timeline in the three stages, is that correct?
It's not correct with respect. And could I have a moment to elaborate on why it's not correct, if it's convenient? I don't want to interrupt your train of thought, Justice Majid.
No, I'm actually done on the first aspect. I've put my question to you.
I know you have a second question, but could I address this first before I lose the thread and then come back to you, if I may?
Yes. I'm pausing for you to answer the first part.
Thank you. So, Justice Majid, what happens here is that the respondents derive the 10 to 30 minutes argument by taking one sentence from Professor Kirsten's second report out of context. So it is true that Professor Kirsten says in his report that it tends to happen 10 to 30 minutes. The brain damage tends to happen 10 to 30 minutes afterwards.
Are you going to go to the record? Are you going to go to the record? Because I was going to ask you to deal with it in the record, because I have it in the report
yes.
as well. If I can just get it.
Yes. Could I ask you to go? Could I ask you to go to Professor Kirsten's second report, which is at page 413.
Yes.
And the passage which is...
What volume is that, Mr. Patlinda?
Oh, I do apologize. It's volume 5.
Volume 5, okay.
And the passage which is relied on is a single sentence, which is at 424.
Yes, that's the last bullet before acute near total hypoxia. Precisely.
So it says, according to Shah and Perlman, fetuses with acute near total hypoxia present during labor with a severe persistent fetal bradycardia for 10 to 30 minutes. That's what causes the brain damage. And then, but what they don't do with respect is they don't read it in the context of the rest of the report. Because, for example, the very next statement says, acute near total hypoxia is caused by a sentinel event during labor. So it's not the same thing. The acute near total hypoxia is what I've called the injury, the second stage. But it's caused by what I've called the first stage, the sentinel event. And then you need to read the other passages with respect of the report. So if you turn the page, you will see that what is said is that, and for some reason it's not highlighted here, I'm just finding it if you give me a moment. What is said is that appropriate fetal heart rate monitoring during labor will identify a sudden onset fetal bradycardia so that appropriate measures such as fetal resuscitation or an expedited delivery can be instituted. I'll just want to find you the reference to that. Yes, it's over the page.
It's at lines 12 and onwards.
Exactly. Yes. So what is being said here very expressly in the very next page is that appropriate fetal heart rate monitoring during labor will identify a sudden onset fetal bradycardia so that the appropriate measures such as fetal resuscitation or expedited delivery can be instituted. Now, of course, everybody knows that the minimum time for a cesarean is 30 minutes because that was the evidence. And if you interpret this the way that our learned friends have, then these two passages together make no sense. Because how on earth could you have appropriate expedited delivery or fetal resuscitation if you know that it's going to take you 30 minutes and yet on the previous page you're saying it's going to take 10 to 30 minutes? It makes no sense. But that's because it's two separate questions, two separate stages. And then...
May I just interrupt you there? I don't like doing that, but
no.
You keep on talking about 30 minutes for a C-section. As I understand it, that's the international standard, and we're running behind it. I've always understood the evidence in the cases that I've been in, including in this case. I think that's the international standard, and we are closer to 1 hour to get theater ready and everybody set up. That is the standard is closer to 1 hour than to 30 minutes in our country.
Yes. I accept, Justice Majid, that was the evidence that was given in the M case, and I do appreciate that's where it comes from. I'm not sure that evidence was given in this case, and I'm not sure that that's the basis on which the full bench relied, because as I understand it, this case took place on the basis of 30 minutes. Now, maybe 30 minutes is unrealistic, but in any event, that would make the point even stronger. If we all know it's going to take an hour, then how on earth could it be? What is the point of doing all of this indicated in page 425 if you know from page 424 that it's going to take between 10 and 30 minutes for brain damage to ensue?
Yes.
So with respect, the point was even stronger. But then it goes on the same page, which says, it says, the doctor needed to assess whether delivery had to be expedited. It's my opinion that a sentinel event probably took place and that due to suboptimal intrapartum monitoring, it was not identified and acted upon. So again, the point is, if it is the case that the moment the sentinel event occurs, 10 to 30 minutes later, brain damage will occur. And if it is the case that it takes half an hour to an hour to arrange a cesarean, then how on earth is this report coherent? But it is coherent because it's answering two separate questions. One is when the sentinel event occurs, and the second is when the injury occurs. And the 10 to 30 minutes relates to the injury. It doesn't relate to the 30 minutes. It doesn't relate to the...
So the sentinel event is the bullet at page 424, and the injury is the one at page 425, which we know is not marked with a bullet. Is that what you say?
No, the other way around. The last bullet on 424 explains 10 to 30 minutes after the injury.
Yes.
So
yes. Other way around. Correct.
Other way around. And then on 425, it's dealing with the sentinel event.
It's the sentinel event.
Yes. My instructing attorney gave me complicated examples about when your head is pushed underwater. That is the event. You are deprived of oxygen. But in fact, of course, the injury only occurs after that has happened a number of times, and it happens later.
Yes. Now,
and then lastly,
yes.
Sorry, lastly on that point, if I could just finish that. Lastly on that point, this issue that is now raised, that the 10 to 30 minutes is dispositive, it was never put to Professor Kirsten. If it was going to be the case of the respondent that the plaintiff's case was untenable because of the 10 to 30 minutes, then Professor Kirsten had to be taken to this and said, but how is it tenable in light of what you say at 424 in the last bullet? It never was. And that is the reason why, with respect, you and I are having this debate without Professor Kirsten's views, and it demonstrates the impermissibility of that approach. Thank you, Justice Majid. I've answered your first question, if I may.
Yeah, now the second question is, much is made of the evidence of Dr. Pistorius, and then the joint expert minute. I'll get to it now. It's at the record page, volume 6, page 597.
Yes.
That's the minute of the agreement between Drs. Pistorius and Dr. Cole, the obstetricians.
I have it, thank you.
And the one I'm interested in is in the last one, number 7. It is doubtful whether it would be possible to perform a cesarean section quickly enough to prevent the neurological sequelae of an acute profound hypoxic event in this time interval. Now, the crucial question here is, which time interval are the doctors referring to there?
Yes. And could I deal with that? Thank you very much. The time interval that they are referring to is the time interval from 4:45 onwards, as I understand it. And could I explain why I say that and demonstrate to you that, in fact, both of the courts below took that approach? Firstly, that was the approach taken by the single judge in the Court Quo that you will see at page 919, volume 10. This is the leave to appeal judgment. 919, volume 10, there is a summary of the argument advanced by Mr. Soni at line 10, and the evidence, and the judge says, Mr. Soni's argument rests on JM7, that's the paragraph you refer to, being taken to mean that even with appropriate monitoring, there would not have been time. If, on the other hand, it is taken to mean that given that there was no monitoring, there would not have been time once monitoring resumed, the implication is entirely the opposite of that submitted by Mr. Soni. Dr. Pistorius' expert evidence was clear, and it does not support the conclusion Mr. Soni seeks to draw. According to Dr. Pistorius, there was clearly insufficient monitoring. No sentinel event was recorded, but a sentinel event would have escaped notice given the insufficient monitoring. The available evidence indicates that there was suboptimal care, which resulting in fetal asphyxia and subsequent hypoxic ischemic encephalopathy, which would have been avoided by appropriate monitoring and action. So that's Judge Keatley's view of this. Then we go to the full bench, and the full bench, if you would go to the same volume, page 950, paragraph 22. This is, I got confused when Justice Taron asked me, this is the judgment with 2 paragraph 22s. It's the first of the paragraph 22s, and it's at page 950. And there the court says, this is the full bench. Dr. Pistorius was of the view that in terms of international standards, the hospital staff had 30 minutes from the time of the decision to refer the patient, which was 4:45, to perform an emergency cesarean section. Given that the baby was delivered vaginally at 5:10, the 25-minute window of opportunity would have been insufficient to perform the emergency procedure. Hence the conclusion, it is doubtful whether it would be possible to perform a cesarean section quickly enough to prevent the neurological sequelae of an acute profound hypoxic event in this time interval. In other words, the full bench too agreed with Justice Keatley that the reference in, because that of course is a quote from paragraph 7 of the joint minute, that was a reference to that time interval. And then lastly, that is also in my submission the effect of the evidence, because when the evidence is given, Dr. Pistorius' evidence at on this point appears in volume 3 at page 204. And you will see there halfway down the page, he's going through paragraph by paragraph of the joint minute, and halfway down the page, line 12, the question says, and then in paragraph 7, it's doubtful whether it would be possible to perform a cesarean section quickly enough to prevent a neurological of an acute profound hypoxic event in this time interval. That is correct, says Dr. Pistorius. Now counsel says, now I want you to clarify that. Applying the international standard of half an hour, if one looks at the diagnosis made at 4:45 and the decision to perform a cesarean section, it means the delivery took place at 5:10. Answer, that is correct. Question, that is 25 minutes. Let us not beat around the bush. No, that is correct. If you apply an international standard, it is unlikely that one would have been able to perform a cesarean section within 25. That is correct. So the evidence is clear that the evidence in chief is clear that Dr. Pistorius understood the time interval to refer to the 25 minutes, not to refer to the hour and a half or the 10 to 30 or anything else. And then in cross-examination, Dr. Pistorius is taken to that passage, but he's not asked about it. And you'll see that at page 244 of the same volume. You can just make a note because there's nothing really to read. But counsel for the respondent in cross-examination at line 13 says, the last point you make, and then he quotes again, it's doubtful whether it would be possible to perform a cesarean section. And the answer is given, that is correct, yes. That is what the two of you agreed on. That is correct, yes. Now counsel for the respondent had heard Dr. Pistorius's evidence as to what the effect of that paragraph 7 was. If that had to be challenged, it should have been challenged in cross-examination.
Well, exactly. My note here and my record says this was not clarified or challenged at all. Now, I just want to conclude by saying one must be careful, of course, when you do these cases, that each case turns on its own facts.
Yes.
And that is why conceivably there are differences in outcomes and not necessarily about the application of the law. And I wonder if you're aware of the recent judgment, I think it was delivered last week in the SCA of MEC Health in Gauteng versus TM. Also, again, a 3-2 split, coincidentally, about causation. Are you aware of that judgment?
So I'm aware of it, but only as of 5 to 10 this morning, when my learned friend, Mr. Brainders, helpfully drew my attention to it. So I'm unable to make submissions on it, but I'm aware of it in broad terms. And while I'm there, Justice Majid, could I draw your attention to a further judgment, which may be helpful, but again, which unfortunately
Before we go to the other,
I'm so sorry.
Before we go to the other judgment, all I want to say about TM, call it TM. The minority judgment was written by Ladwaba AJA and the majority judgment by my brother Rogers AJA, and he's the one that drew my attention to it. And again, it is split on the facts, and therefore I say that one must be careful to not to rely on judgments which turns on facts. And I think this is the criticism you have against the full court. I'm not necessarily saying you're correct, but that's the point you make. It turns on different facts.
No, with respect, that must be so. And with respect, that is indeed whatever else the full bench did or didn't get right. It is clear when you read its judgment that it essentially went and looked at the majority in the other M case, and it applied those conclusions, but those conclusions were based on the facts that had been led there and the expert evidence that had been led there. And that is indeed, and of course we've explained why in our heads that is impermissible in terms of section 34 and in terms of the general principles for obvious reasons, because it means that, you know, my clients' legal representatives were never able to cross-examine those experts. They were never able to do it. And the expert evidence here was quite clear. So with respect, that's right. Could I just give you the reference to the additional case before I forget, for the benefit of the court? It is unreported and it's from Limpopo. It doesn't seem to be on SAFLI. We will make it available to the court. I did draw my learned friend's attention to it this morning, shortly after it was drawn to my attention. It is the judgment of LM versus the MEC, case number 31261/2015. It's a judgment of Swanepoel AJ, and it's delivered on the 8th of March, 2021. And what it does is it looks at very recent scientific evidence and makes the point that some of the scientific evidence that was before the SCA in some of the earlier cases has now been effectively superseded. Now, I'm not trying to adduce that scientific evidence because I'll fall into the same trap as the full bench did. The point I'm making is that it cannot be that one case of brain injury because of allegedly inadequate monitoring is the same as another case, or is the same as another case. Everything depends on the facts on the ground and the expert evidence given in trial. And I'm referring you to this just so that the court has the full benefit of it, but it demonstrates with respect that the full bench's approach in my submission cannot stand.
Thank you. Thank you, ACJ.
ACJ, may I come in here?
Yes, do.
Mr. Budlin, confining ourselves then to the evidence in this case, you read us the passage from Dr. Kirsten's evidence about warning signs, and I think you construct the different phases of what happened here based on that.
Yes.
He immediately said, but obviously I'm not an obstetrician. He's a specialist pediatrician specializing in neonatology. Did Dr. Pistorius, who was the obstetrician, testify, is there any evidence from him that the onset of the sentinel event causing, I think somewhere you referred us even in Dr. Pistorius's report perhaps to a sudden onset, which is the nature of a sentinel event. Did Dr. Pistorius say that prior to the onset of the sentinel event, there would likely be warning signs?
Justice Rogers, I'll deal with that. Could I just say, my understanding is that it's not prior to the sentinel event that there are the warning signs. It's after the sentinel event, but before the injury. That's my understanding of the position. So perhaps I could just clarify that.
Yes, but as I understand it, the acute event causes a near total shutting off of oxygen. So, yes. And one is suddenly going to see bradycardia on the CTG. But either way, did Dr. Pistorius suggest that you would see any warning signs before, if what I can call it, the 10 to 30 minutes episode?
Yes, as I'll need to find, I need to have a look at what is absolutely clear. I don't know whether he said, whether he divided the stages in the way that I have, but what is absolutely clear is that he took the view that if you monitored the fetal heart rate, then you would receive signs which required you to engage in the mechanics of buying time, and that's the real point.
Now, I understood, I must say, when I read his evidence, I understood that to mean the beginning of the 30 minutes.
Yes.
And if I can refer you, because I think a question was asked by one of my colleagues, was Dr. Pistorius asked pertinently whether, if I can call them the interim measures, that happened to be the expression we used in the recent SCA case, the intrauterine resuscitation pending a C-section or pending natural delivery. He's asked about that in volume 3 at the bottom of page 205. He says at the foot of the page, if intrauterine resuscitation had been done, it could have improved the outcome. We cannot say in an individual case whether that would be sufficient to improve the oxygenation of the baby. And then over the page, 206, about line 806, the benefit of buying time is that the half an hour ideal time to decision to delivery is difficult to achieve in practice. I think that's the difference perhaps between the 30 and the 60 minutes in the developing world. And the intrauterine resuscitation buys time to keep the baby relatively safe until C-section.
Yes.
So, and then I think he's asked, if those actions were implemented and it brought another half an hour, what would the impact of that be? So I'm thinking he now posits perhaps that it takes 60 minutes to deliver the baby, but you've had intrauterine resuscitation, say, which trying to buy extra time. He says, "Milady, I cannot really say, because it is also impossible to determine whether there was at this time at 4:45, if the decision was made to deliver, if, for example, continuous CTG tracing, that you monitor the fetal rate, heart rate continuously. From there, we can see, it's all a bit muddled, from which is evident that I think he's saying if there had been monitoring which showed fetal distress, then I can make a comment on whether it would have helped or not. But it appears, and then it could have happened half an hour earlier and has managed to resolve itself by now. So as I understand it, he's saying perhaps the sentinel event, which is one of these unexplained sentinel events, happened half an hour earlier. It resolved itself and the damage was done by then.
Yes, but if I could just take you to the rest of that page, Mr. Stratham then says, because of course this is getting muddled, not muddled, but enmeshed in the debate about we don't know what happened before 4:45. And then Mr. Stratham says, just forget about this case. If a specific time a decision is made that there should be a cesarean section performed in a patient because there is fetal distress, if you can buy time by implementing these actions, it would improve the prospect of performing a cesarean section in time. And the answer that is given is that is correct. Yes. So Justice Rogers, with respect, the question you've put to me is a very fair one. He doesn't do the stages in the way that I've articulated. And I accept that there might be a divergence, but what he makes absolutely clear is that the regular monitoring can buy you time beyond the 30 minutes and thus allow you to do a cesarean section safely.
Because it allows you to know that you may not accept the way I put it to you now, but as I'd understood the evidence up to now, the sentinel event has occurred. You now have a problem with oxygenation and you try interim measures to do the best you can until the baby can be delivered.
Yes, that's absolutely right. And whether you call that 2 stages or 3 doesn't really matter with respect because of the conclusion. That's absolutely right.
Can I then just clarify one thing about this 30 or 60 minute standard for a C-section? As I understand it, that has nothing to do, but correct me if I'm wrong, and I'm not sure if it's explained in the evidence in this case, that has nothing to do with the scientific view of causation and how quickly a C-section will avoid harm. It is really based on hospital logistics, which is why there's a different measure in the developing world. I would have thought that the basic proposition is that once a C-section is diagnosed as required, you have to do it as soon as possible. You can't wait 30 minutes if you could do it straight away.
Exactly.
And of course, is it not also the case that when you see a problem on the CTG, the nursing staff or the doctor in a public hospital may not know whether he or she is dealing with an acute event or a partial prolonged event? You simply know that you now need a C-section.
I accept both of those propositions, if I may. Yes.
Yes, because I know if you look in the developed world, when you look at acute profound cases, when they're talking about negligence, they say, well, if you had done this operation within 9 minutes rather than 14 minutes, that becomes the causation focus. So I just wanted you to invite you to reconsider the proposition you made that what would be the point of setting a 30-minute standard for C-sections if that couldn't avoid the harm?
Oh, no. If that was what I conveyed, then I misspoke. It wasn't a 30-minute standard for C-sections. It was a 30-minute monitoring period. I was trying to say, what I was trying to articulate, Justice Rogers, is if one accepts the reading of Professor Kirsten, which I don't accept, but if you accept the reading of Professor Kirsten, that the moment this happens, you've got 10 to 30 minutes and then it's done. Well, then it's very odd to only have monitoring of the fetus every 30 minutes because it leaves a very, very, very strong chance that it's going to be entirely pointless. Whereas if you understand that the monitoring of the fetus is to see the warning signs, then to buy you time, and then you've got the 10 to 30 minutes, then it makes perfect sense. And so it wasn't about a 30-minute standard for deliveries that I was trying, for C-sections that I was saying makes no sense. It was the 30-minute monitoring standard that makes no sense if that is the case. Because if it were the case that Dr. Pistorius, I beg your pardon, that Professor Kirsten's report meant what our learned friends seek to say, then it effectively would reduce the 30-minute monitoring period to be largely meaningless. Could I say one last point on that in answer to your first question, Justice Rogers? You correctly point me to the fact that Professor Kirsten and Dr. Pistorius are not entirely ad idem in the way they describe things, which is unsurprising for two expert witnesses. But my point is this, and the reason I focus so much on Dr. Kirsten is because it is on Dr. Kirsten's expert report that our learned friends still seek to build their new case. They seek to wrench that line about 10 to 30 minutes from Dr. Kirsten's report. And what I wish to demonstrate is that even if you rely on that line, it can't sustain their case because Dr. Kirsten's evidence was at odds with it. But I accept that, of course, the court will have regard to all of the evidence, and including what Pistorius says.
Mr. Badender, I know this might be a question more appropriate for the respondent, and I probably will put that to the respondent's counsel. The respondent wishes to argue in this court, if I understand their case in this court, that the sentinel event likely did not occur before 4:45. And counsel for the respondent will expound on that, but it seems that they reached this conclusion on the basis of inferences drawn from the expert evidence. But this was not the evidence given by the expert evidence, or these inferences were not drawn by the experts themselves. And the experts, the way I understand the evidence, appear to accept that the injury likely occurred between 3:15 and 4:45.
Yes. Justice Turon, with respect.
Yeah, on my reading of the evidence, the experts didn't narrow down the window of time in the manner in which the respondent, I know I'm preempting their argument, but it seems that they are narrowing down the time, but we'll hear what Mr. Brander says. What is your comment about that? If that is what their case is now in this court.
No, with respect, that does seem to be their case, and I'm very grateful for the question, because that's the second of their first propositions. The first is the 10 to 20 minute point, the 10 to 30 minute point, which I've dealt with. The second is that the event occurred at 4:40 or 4:45. And with respect, it's important that I address it. We say that that is not a permissible argument on the facts before you, because the joint minute that we've gone to at 597 expressly says, expressly says at paragraph 5, it is likely that an acute profound hypoxic event occurred in the time from 3:15 until 4:45, where there is no recording of fetal monitoring during active labor. So the joint expert report was that it was between 3:15 and 4:45, and impliedly that you couldn't narrow it down any further because there was no fetal monitoring. In the evidence that is given by Dr. Pistorius, it is never put to him that it must have occurred at 4:40 or 4:45. And as I now understand the argument is now that it must have occurred at 4:40 or 4:45 because of the length of time, the 10 to 30 minutes referred to in the other expert report of Professor Kirsten. With respect, it had to be put, either the evidence had to be led or it had to be put to the witness. And neither of those two things happened. So with respect, I embrace your implicit criticism of that proposition.
Mr. Butlander, what should we make of the now proposed or withdrawal of the concession which was made in the trial court on negligence?
Yes. Justice Mhlantla, in my submission, there is no, well, I make 2 points. Firstly, it's not at all clear to me on what basis it is permissible to withdraw a concession of that kind. I'm well aware that one can withdraw legal concessions, but that is not a legal concession in that sense. It is a conclusion on the facts, and it is a conclusion regarding the element of the claim. But never mind, let me ignore that for a moment. What I don't understand with respect is on what basis the concession is sought to be withdrawn at all. Because where the Department of Health guidelines say you must monitor every 30 minutes, and where it is common cause that here there was no monitoring between 3:15 and 4:45, I don't understand on what basis it can be said that it wasn't negligent. It seems that what is done is a conflation between negligence and causation, but of course that's not permissible or appropriate. But if a government standard says you must monitor every 30 minutes, and it's common cause that you don't, and there is no explanation from a witness as to why you didn't in the particular case, on the facts of a particular case, then it must follow with respect that it's negligent. And so even if it were permissible notionally to withdraw the concession, I don't think, my submission is that it's not sustainable on the facts.
Correct me if I'm wrong. The respondent seems to be saying that even if there was no monitoring was conducted during that 1.5 hour period. That would not be, one cannot say that some injury or sentinel event occurred during that period. It's not possible.
Yes, I don't, with respect, they seem to say that the court should find that there wasn't an event during that period, but that the event occurred at 4:40 or 4:45. But they don't explain with respect on what basis they can say that, when that was not the evidence, it was not put to the witnesses, and the very reason that we can't identify the event with greater specificity is because their nurses were not doing the monitoring that they were required to do. And it goes back to the point I made at the beginning, Justice Mplantla. It's one thing to say a plaintiff hasn't proved their case on causation. It's another thing to say a plaintiff hasn't proved their case on causation because we can't specify the time because we didn't do the monitoring that we were meant to be doing. In other words, the negligent conduct is the reason we can't provide greater specificity as to the precise time. That, in my submission, is not sustainable.
Mr. Butler, let me take you to causation, please. I'm sorry, to jurisdiction.
Yes.
In your opening, you relied on you pegged it on the state obligation insofar as the bill or rights in the Bill of Rights are concerned, in particular section 7. I think you referred to some other section as well, I forget which. And I must say that gave me a bit of discomfort, but I was comforted because I'm attracted more to your section 34 argument. I was comforted when, in response to one of my colleagues, you now again referred to section 34 and placed reliance on it. Of course, the fact that in your opening you did not refer to it in no way suggests you had abandoned it.
No.
Let me say why I have a bit of a discomfort with the reliance on section 7. I have a sense that it would mean that in virtually every matter involving the state or organs of state and where causation an issue, it would be very difficult, if not impossible, for us to ever say we do not have jurisdiction. And I doubt that that's the point you are making. And if that is not the point you are making, can you please just delineate your reliance on section 7? In what sort of cases must it apply, and in what sort of cases must it not?
Justice Madlanga, thank you for the question. I must apologize. I was rushing because I didn't want to eat up my time. Let me deal with it more carefully because you have very, very helpfully do it. Could I start by reading you the quote on which I relied and then explain what it means and what it doesn't mean? In Mashongwa, which was, of course, the case about negligence in the train and the person who was thrown out of the train, this court said as follows. It said, although it may not look like the outcome turns on, and that was a causation case, of course, although it may not look like the outcome turns on the meaning or vindication of any constitutional provision, all right, Section 7.2 and 12.1c of the Constitution are the pillars on which the superstructure of this case rests. Mr. Mashongwa's claim owes its origin largely to the obligations imposed on PRASA, an organ of state, by these provisions. In addition, an inquiry into wrongfulness focuses on the policy and legal convictions, and therefore this court has jurisdiction. So let me say, I do submit that if Mashongwa was a constitutional case, then so is this one for the same reasons, because here you have 7.2, 12.1c, and 27, the right to of access to healthcare. But that doesn't mean that every case is going to be a constitutional issue, because, for example, this court has said since Busak that a decision that it is wrong on the facts, an appeal on the grounds that a decision is wrong on the facts, is not without more a constitutional issue. So it's only where the test will be, where the case will raise some sort of legal principle, in this case, the appropriate standard for causation, or in this case, the permissibility of relying on factual findings of another court. So I'm not suggesting that every medical negligence case should flood through your doors, not for a second. But in any event, you very helpfully, with respect, make the point, and we do embrace it, that this case is very unusual because there is a Section 34 right at stake. And the Section 34 right again, is not because the SCA, not because the full bench got it wrong on the facts. Busak tells us that's not a constitutional issue, never has been. But it's because the SCA, the full bench, adopted an approach which relied on factual findings of another court. And in doing so, that breached Section 34. And that is unquestionably, in my submission, a constitutional issue for much the reasons that the decision of this court in Van der Walt about the gynecologist who was convicted of culpable homicide, where the question was it permissible to rely on evidence that had not been put to him? This court said that was a breach of the fair trial rights. And of course, and therefore it had jurisdiction. And that, with respect, was quite correct. And similarly, in this case, under 34 rather than 35, it is a constitutional issue. So yes, I don't ask you to find that every medical negligence case against the state is impermissible. And let me say, if this was a medical negligence case against Mediclinic or one of the other private hospital groups, and the finding had been a factual finding relying on some other SCA judgment, we would say exactly the same thing applies, even though it's a private entity rather than a state entity. So it's not about the existence of state or private entity for that purpose of the constitutional leg.
So, if I may follow up on the question of jurisdiction. I'm sorry, Acting Chief Justice.
Okay, we are at 11:15. We can either try and complete Mr. Butlender's address before we take the tea break, or we take the tea break now.
Deputy Chief Justice, I'm essentially done. I've gone in a very different order, but I've covered everything I wanted to cover. So if it's convenient, I'm happy to deal with the remaining questions.
Maybe let's take Justice Theron's, you can take Justice Theron's question. And if there is no other colleague who still has questions for you, we can then take the tea break. But if there is a colleague who has a question, we'll take the tea break and they can continue after. Okay.
Thank you, Acting Chief Justice. Mr. Butler, in response to the questions about jurisdiction from my brother, Justice Matlanga, you submitted that one of the issues here is the appropriate standard of causation. And in that regard, the applicant is relying on the decision in AM, I think from the SCA, and where there was a minority judgment as well. Is that correct?
We don't rely on that. We don't rely on the majority. We, if anything, rely on the minority. Yes. Yes.
But does that show a difference between the application of the test? Was the same test not applied in both the minority and the majority judgments, but the difference related to factual findings?
Justice Theron, I apologize for asking, did you mean in M, that in M the case didn't turn on? Yes. My understanding, but I will need to relook at M, my understanding is that M did partly turn on the correct test to be applied, in the sense that the minority embraced the Lee test, a more flexible test of causation, whereas the majority didn't. But more importantly, in this case, the full bench very expressly criticized the High Court, the initial judge, for embracing what it regarded as the more flexible Lee test derived and the test in the minority in M. And you will see that from the full bench judgment, because in the full bench judgment at paragraph 18 on, that's volume 10, page 947, and then the passage I wish to refer to is at 948, page 948, line 3. There is no indication in the judgment that the quota quo arrived at that conclusion by applying the but-for test. The approach of the quota quo appears to be similar to that of the minority judgment per Majid and Chikvi in M versus MEC, where there was, in this case, and then it dealt with the facts, the minority found the following. The minority further found that the lack of negligent monitoring resulted in the risk of hypoxia. This, the minority found, established factual causation on a balance of probability. Drawing on the reasoning in Lee, the minority went on and said the following. So I'm not saying Justice Ponnen in M necessarily said Lee was wrong or anything of the sort, but certainly this full bench understood that there were two tests. There's the traditional test and there's the Lee test. And in this case, it criticized the High Court for having adopted what it regarded as the Lee test, or the more flexible Lee test that relied on by Justice Majid in M. And so that is the reason why I say there is a debate about the proper test. We say we come home on either, but this case certainly demonstrates that there is a debate about the proper test.
Didn't the full bench apply the but-for test?
It did, and it didn't apply the Lee test. And
the trial court also applied the but-for test? Or
what
is your submissions about what test the trial court applied?
I also thought the trial court applied the but-for test, but the full bench took the view that the trial court's test was effectively the Lee test. And so given that we are appealing against the full bench's judgment, there is a debate about the proper test to apply.
But is that enough to say that there is uncertainty about the proper test?
Oh, in my submission, absolutely. Because if I'm arguing a case tomorrow about this in front of a single judge, my opponent is going to say, but have a look at the judgment of Tobani AJ, which criticizes the High Court judge for applying the more flexible Lee test and requires the application of a strict but-for test. Now, that is the effect of the full bench judgment in this case. We submit wrongly. We submit that one does use the but-for test, and if we come home, that's the end of it. But if we don't come home on but-for, then the facts of this case do require, or the circumstances of this case do require, the application of the Lee test. And so I do submit that there is confusion in the courts, or confusion might be too strong. There's disagreement in the courts about the appropriate test to apply, and it's necessary for this court to deal with that question.
Thank you, Mr. Budlander. Thank you, Acting Chief Justice.
Thank you. It looks like there would be no further questions for Mr. Budlander from my colleagues, but when we come back from the tea break, if there is a further question from colleagues, they will indicate when we resume. We are going to take the tea break now. The time is 26 or 27 minutes past 11. It will be 15 minutes. I think to be on the safe side, let us say we will resume at 22:12. We adjourn.
Court will adjourn until 11:40. Please note that during adjournment, you are welcome to switch off your video and mute your microphone, then rejoin with the video and sound when the hearing recommences at 11:40. Should you exit, you may use the same link to rejoin the hearing.
Okay, are we all back? Can we start? I take it, colleagues, there were no further questions for Mr. Patlender? No, they weren't. Okay, Mr. Brainders?
Acting Chief Justice and Justices of the Constitutional Court, we would like to start with the injury.
And I just mentioned, Mr. Brainders, as you start, that I remind colleagues that you said you are happy to do without the 10 minutes address without interruption. You may proceed.
Thank you. We would like to start with the injury and the nature of the injury because once identified, we can then accurately identify the appeal issues. Now, the court can accept that all the experts agree with the radiologists who are the key experts on the nature of the injury. They agree with the radiologists that the injury and the nature of the injury, in this case, was an acute, profound hypoxial insult to the fetal brain.
ACJ, can I ask, do we have Justice Madondo with us?
Well, if he has fallen off, Justice Madondo?
I'm following up on that, Acting Chief Justice.
Yeah, okay. I understand that the arrangement is if he falls off or any of us falls off, we'll proceed and...
He's here, ACJ, he's here.
He's here, okay, all right. Thank you. Yes, Mr. Brainders, please proceed.
Thank you. So the court can accept that as a matter of objective fact, what you had here was an acute profound injury, that is an acute profound hypoxial insult to the fetal brain. Well, what is that? And Professor Kirsten spent some time telling us what that is. And he confirms both these reports in his evidence in chief. And he says that the way his reports say that the way it presents is by way of a sudden onset of fetal bradycardia. That's the way it presents. And the bradycardia persists for between 10 to 30 minutes, after which the fetus will probably die in utero. But brain damage occurs within 10 to 30 minutes. So that's what Professor Kirsten says. Now, the question that arises from those two facts is this. Was it the failure of the hospital staff to monitor at 3:45 and 4:15 to monitor the fetal heart rate? Was that failure the cause of this unidentified sentinel event? The answer to that question is no, because of course, Professor Kirsten says it's an unidentified sentinel event that occurs during labor, and it's not brought on because the nurses do or don't do something. It occurs. So we can't say that they are the...
Mr. Brainders, I think because the debate turns a lot around what the exact facts or rather the evidence is, I think the best starting point is to take us to the exact parts of Professor Kirsten's evidence for your timing.
Yes, so I set that out in the heads at paragraphs 14 all the way through to 21 with the references there.
Take us to the record and please read the relevant parts of the record itself.
So, all right, so let me start with the joint minutes of the neonatologists. They say in the joint minute, volume 6, page 591, they say that they agree with the diagnosis of the radiologists that the injury is in keeping with an acute profound hypoxic insult to the brain of a term infant. Then, that you will also, volume 2.
They make even paragraph 12 of that joint minute as well. I think they make that point.
Yeah.
All right. Taking us elsewhere.
Then, see the evidence of Professor Kirsten, volume 2, page 132, lines 6 to 19. So he agrees that that's the nature of the injury. They also agree that's the...
Sorry, what was the page on volume 2, Mr.
Volume 2, page 132.
Yes.
Forgive me, Acting Chief Justice, it's volume 2, page 132, and you can look at lines 6 to 19. That's Professor Kirsten, where he confirms the nature of the injury. Then, in the joint minutes at volume 6, page 593, the neonatologists agree that the clinical picture at birth, severe depression requiring extensive resuscitation, the large basic deficit after birth, early onset seizures 5 hours after birth, are in keeping with an acute profound hypoxial insult to the minor's brain, are in keeping with a severe hypoxial brain insult during labor. So that's at volume 6, page 593. Now, the neonatologists, as we point out in our heads, don't say anything about the timing, but the pediatric neurologists, and you can go for this to the joint minute at volume 6, page 609 to 10. Volume 6, page 609 to 10. The pediatric neurologists agree that the insult occurred within close temporal proximity to labor and delivery.
And what does close mean?
Well, they don't say it. That's just what they agree on. But what we say in our heads, Justice Madlanga, is that the evidence of Professor Kirsten, and I suppose you're going to ask me to take you there, but the evidence of Professor Kirsten in his report, which he confirms in his evidence in chief, is that it takes 10 to 30 minutes for brain damage to set in. And this is confirmed by Kiki J in her judgment in leave to appeal. He said that this happened close to delivery because otherwise the fetus would have died in utero. And that, I'll take you there. Volume 10, page 920, line 11. That's the judgment of Keatley J. And at volume 2, page 133, line 17 to 134, line 6. What Professor Kirsten says is this baby was delivered very close to fetal death.
How, if at all, does this evidence deal with the warning signs before any brain damage? Warning
there are
signs.
none. That's the point. There are none. That's the point. There are no warning signs of an unidentified sentinel event. And can I explain why we say that? Just let's go to the evidence where both Professor Kirsten and Dr. Pistorius deal with the so-called resuscitation. Now, I want to deal first with Professor Kirsten. I can get there. Professor Kirsten In a moment, I'll find my notes. So there was a notion in the evidence, and on which Keatley J. relied, that measures short of a C-section could have been taken by the nursing staff. And they talk about resuscitation measures. Now, can we just point this out? That notion arose on the back of a belief by Professor Kirsten, relying on the statement of the mother, that there had been meconium present at 2200 hours on 3 April 2009. That's it. See the cross-examination of Professor Kirsten at volume 2, page 153 to 4. The volume 2, page 153 to 4. He assumed that there had been fetal distress some 7 hours before delivery. But that belief, that assumption is fundamentally, factually flawed. That is because the obstetricians in their joint minute at page 597, paragraph 4, say at 3:15, there was still evidence of fetal well-being, clear amniotic fluid, and normal fetal heart rate, which makes a sentinel event severe enough to cause an acute, profound hypoxic event during the active phase of labor until that time unlikely. So Professor Kirsten, when he talked about measures that you could take, thought that there was fetal distress much earlier. Well, there wasn't. That's the first point. The second point is this. He even, as we point out, backtracked from his assertion that there had been fundal pressure during delivery. That's see the cross-examination, volume 2, at 155 to 6. And he conceded in his report that here the radiological picture is of an acute, not a partial prolonged insult. Now, in his evidence, what he said was there is a fundamental difference between the two. He talks about an acute profound as akin to strangulation. It is the total or near total cutoff of oxygenated blood supply to the fetus. You're not supplying any blood to the fetus when there is an acute profound insult. Very different to a partial prolonged. In fact, Professor Kirsten says that's where you get intermittent cutoff. So that's where you get a cutoff and it releases, and you get a cutoff and it releases. Here, the total cutoff of oxygenated blood supply lasts from the time that the sentinel event starts until the baby is delivered or until it dies if it isn't delivered.
Mr. Brainders, are you?
I'm not done.
Okay.
I'm not done. I just want to go to Dr. Pistorius. Now, in the examination in chief, that is at volume 3, page 205 to 6. Dr. Pistorius talks about the resuscitation measures that could have been taken. But where he talks there about the resuscitation measures that could have been taken, that is premised not on an unidentified sentinel event occurring suddenly and unexpectedly, including the blood supply to the fetal brain. It's premised on a partial prolonged hypoxic insult. So where there's a partial occlusion, and in the latter case, there's a reduced supply of oxygenated blood supply to the fetal brain. Now,
in which page are you referring to now?
Volume 3, 205 to 6. And what he says is, he confirms that where there is fetal distress over a period of time, he would have expected to see a partial prolonged type injury picture in the MRI scan. Well, here there's none. He also said that he would have expected to see meconium-stained liquor. There is no record of meconium-stained liquor observed before, at or shortly after birth. See Dr. Pistorius in his addendum report at volume 5, page 467. Volume 5, page 467. Also see the examination of the neonate record at volume 9, page 820 to 21. No record there of meconium stained liquor. The first reference to brownish fluid being drained upon suctioning of the neonate is at 6 o'clock on admission to the ward. That is volume 9, page 817. So when he talks about resuscitation measures, he's talking there in the context of a partial prolonged insult. In other words, he's talking there in the context of detecting fetal distress about which you can do something, i.e. resuscitate the mother. The problem is,
I don't want you to go too far before Justice Nhlanhla asks you the question she wanted to ask you. So let's have her ask you the question.
Thank you, ACJ. Mr. Brainders, you referred us to the joint minute of Dr. Pistorius and Dr. Cole, and you read para 4 thereof. I would like you to comment on what they say at para 5, which reads, it is therefore likely that an acute profound hypoxic event occurred in the time from 3:15 until 4:45, where there is no recording of fetal monitoring during active labor.
Correct, it did take place in that time, but the question is when did it take place? And what we submit, that if you look at if you pay close attention to particularly Professor Kirsten's evidence, then this is an unidentified sentinel event, which is the sudden onset of a severe fetal bradycardia. This is not where you get a slowing down and it comes back up and so on. It's not that sort of thing. It's the sudden onset of a severe fetal bradycardia that persists. Now, a severe fetal bradycardia is a fetal heart rate that drops to below 100 beats per minute. That's severe fetal bradycardia. It occurs, it persists, and you've got to get the baby out. Now, what he says is, from the time that happens, it takes 10 to 30 minutes to brain damage, to fetal brain damage. That's what he says in his report. That's what all the literature, he says, that's what the literature says. Now, if that's the case, then we say this is something that must have taken, and he also, by the way, says in his evidence that this fetus was near death when it was delivered because its state was so depressed. Its state was, it was in such a low state that to him suggested that it was near death. And we say, if you look at what the pediatric neurologists say, and they say this happened temporarily close to delivery, we say you are talking then about a 10 to 30 minute period before delivery. So other period you're talking about. So yes, it's true that it happens between 3:15 and 4:45. But when in that time did it happen?
Mr. Brainders, can you please assist me here? Mr. Butlander referred us to page 133 to Professor Kirsten's testimony when he was dealing with the 3 stages. Are those irrelevant here? And what was he describing? Was he not describing what actually happened in this matter? Are you saying that he was not referring to what actually happened in this case?
No, those 3 stages are really 3 stages cooked up by the legal team.
So on what basis should we say they are cooked up then?
Because Professor Kirsten never talked about 3 stages. He only talked about 1 stage, the sudden onset of a severe fetal bradycardia. And
but that is his testimony.
Well, but he doesn't talk about 3 stages. Can I just take you to 133? At 133, he says, He says,
let's start from the top, when he's talking about Victor until the end.
yes. So he says, well, at the top, he says, if you go back,
That volume 2, page 133, you are referring us to.
Yes.
yes.
Okay.
So if you go back to 132, it starts with in evidence in chief, his counsel asking him, Professor, this is at line 20, page 132. On page 22, the last bulleted paragraph under that first heading, you refer to articles, as I understand it, of Shah and Pullman. He says that is correct. You go on to say what you know you regarded as important in the context of this case. He says that is right. Would you tell us what it is? He says this is one of the causes. Victor had an acute, profound hypoxial insult. Well, that's correct. That's true, he did. And he says in babies, so we're all agreed about that. He says in babies, it is not like experiments and studies and fetal lambs. It is very, very difficult to pinpoint exactly when it actually started. It is there if there's a cord prolapse, when the cord, we're not talking about that here, or if there's a ruptured uterus, but during labor, it is not that easy. And that is why fetal heart rate monitoring and fetal frequent observations are so important, because it will give you an indication that climbing up the onset. Well, I don't know what that means, but he said in his report that it is it's a sudden onset. There's no climbing of the onset. But I do want to go to the bottom, which that is where.
No. I think let's finish the next line where he says, then the duration of the actual final bradycardia varies, and it depends on if there is total loss of oxygen provided for the fetus.
But there is a total.
And you seem to be saying that it varies between 10 minutes and 30 minutes.
That's what he says.
Well,
this is where he deals with the literature in his report. And he says the literature says it takes between 10 and 30 minutes for brain damage to set in from the time of an unidentified sentinel event.
Okay, let's go to the bottom.
So then he says, and this is what was focused on earlier, he talks about a total abrupture. He says it is the same like strangulation.
Mr. Brendas, are you reading at the bottom of page 133?
Forgive me, Acting Chief Justice. It's halfway. It says court, yeah.
Okay.
If there is a total complete abrupture, that'll give signs of a radiocardia, say within 10 minutes. It is the same like strangulation. There's total separation, and so on. Now he says the fetal bradycardia can last for 30 minutes, but that is the fetal bradycardia, the slow heart rate. But of course, the slow heart rate is a sudden onset. That's what he says in his report. If there is hypoxia, the heart muscle requires oxygen. So the final sign will be that the fetus will have a very slow heart rate. But before the onset of that slow fetal heart rate, the fetus from the CTG will have changes in the pattern of the CTG. Now, can I just point out that here we can't rely on the CTG because the nurses say it's unreliable. Dr. Kirsten says it's unreliable, and it's not even labeled, so we can't rely on it. It was taken at just after 2 o'clock in the morning, and we know that at 3:15, the condition of the fetus was reassuring. So that CTG tells us very little about an unidentified sentinel event that happened in this case. But then he goes on to say this. I do not want to go into that because I'm not an obstetrician, but it will give you warning signs. You will get warning signs. Well, the fetus will pass meconium as a warning sign. There is something going on here. But the end of the epoxy will have a very slow rate, and if he is not delivered, he will die in utero. And again, what we say is what happened here was Professor Kirsten assumed that there were warning signs in this case. There were not. There was no meconium passed at or before 3:15 at all. And in the hospital...
So he is not I'm sorry to interrupt you. So he is not saying, according to you, that if there was proper monitoring, warning signs would have been detected.
No, what he's saying,
Is that what you're saying?
Correct, but what he's also saying is this. What he's saying here is, in this case, he would have expected them to pick up warning signs if, for example, there was meconium, or if the CTG started showing up unreassuringly. That's what he would have expected.
But was the CTG done?
Well, there was a CTG done much earlier.
Yes, but during the period after 3:15, was the CTG done?
There's no requirement in the guidelines that you
run. But was it done or was it not done?
No, it wasn't done, but there's no requirement. In other words, in this case, the accusation against the hospital is not that it was negligent because it didn't run a continuous CTG. That's not the accusation.
The accusation is that there was no monitoring.
Correct, there was no monitoring every half hour, which is the least they expected according to the guidelines. But here's the point. The point is, when Professor Kirsten talks here about warning signs, he's talking about warning signs in the context of a partial prolonged. He's talking about, for example, fetal stress like meconium, like a CTG showing you unreassuring signs. But we don't have that here, and we know that that happens in the context of a partial prolonged situation, where over a period of time, you get the partial deprivation of oxygenated blood supply to the fetus. And then you get warning signs. But
I'll just ask you one last point, Mr. Brainders. If monitoring had been done during that period of 1 hour, 30 minutes, what kind of monitoring, according to the respondent, should have been done?
Fetal heart rate monitoring. So they check the fetal heart rate, and you usually do that by auscultation under the guidelines, the nursing guidelines, the maternal guidelines. That's acceptable.
Now,
what? Excuse me?
Oh, sorry to my colleague, Justice Rogers. What would have been used to monitor fetal heart rate?
Auscultation. You listen to the fetal heart rate with a sort of handheld monitor.
And is Professor Kirsten here not saying that the final sign would have been the fetus would have a very slow heart rate before the onset of that? So I'm confusing myself now. Is he not saying that the fetal heart rate, the slowing of the fetal heart rate would have been detected?
No, what he's saying is when a sudden severe fetal bradycardia happens, when the fetal heart rate drops severely below 100 beats per minute, you might not pick that up immediately, but of course you are required to monitor every half hour. And if it happens before you do the auscultation, before you listen to the fetal heart rate, you will of course pick it up. The next thing you need to check is, well, for how long does that continue? Is there anything you can do to bring up the fetal heart rate? And there, of course, you will try resuscitation measures. The problem with
when one detects the slow fetal heart rate, is that not the fetal bradycardia?
Yes, but the fetal bradycardia, in the case of an unidentified sentinel event, it happens suddenly. It's a sudden onset. It's like a car accident. I mean, it's a crash happens. This is not the sort of the slow dripping situation which you get in a partial prolonged. This is a massive assault on the fetal blood supply.
I thought my reading of his evidence was that the bradycardia happens before the brain injury happens.
No, an unidentified fetal an unidentified sentinel event presents with the sudden onset of fetal bradycardia. That's what he says in his report. That's how it presents. That's what the literature says. That's what he confirms. That's how it presents. Now, if that's the way it presents.
Thanks. Those are my questions. Thanks, ACJ.
Can I just, Mr. Breinders, follow up on that, because I want us to get the sequence clear right here. There's a sentinel event that can occur. Some of them are like a prolapsed cord, or you could have a uterine rupture. But here we know there's an unidentified sentinel event. After that event, there's a slowing of the heartbeat and fetal bradycardia may ensue. Am I right so far?
Well, it does ensue. It sets in.
Yes. But that will be picked up once you monitor and you see that the heart rate has dropped to below 100 beats per minute, and it stays there. It decelerates to below 100, and it doesn't come back up as it's supposed to come up. And that is an indication that there is the fetus is in distress. Am I right so far?
Correct, but remember, what you're picking up when you monitor the fetal heart rate, when there is a severe fetal bradycardia in the case of an unidentified sentinel event, is not a fetal heart rate that does this. Yes.
I understand that. We're on the same page.
And it's persistent. It stays.
That's what I just said. I said it stays there. It doesn't come back up. It's a deceleration below 100, and it doesn't come back up. We're on the same page. But that happens after the unidentified sentinel event. And you'll only pick that up if you do the monitoring, not so.
Correct.
Right. So there's sorry, can I just finish? There's the sentinel event. There's the dropping that stays there. It's the fetal bradycardia. It can last up to 30 minutes. And because of and just in layman's terms, just because of that starvation of oxygen to the brain damage occurs because there's no oxygenated blood going to the brain. And the damage then occurs. Am I right there?
Correct.
So then, when you say the three-stage process is cooked, I'd like to just for you to elucidate that further. Because all that Mr. Butlander is saying, as I understood him, he says, here's the three stages. There's a sentinel event, either prolapse cord or a uterine rupture, or an identified one like here. Then the second stage is there's fetal bradycardia, you pick that up, and then third, the injury then occurs. That's the three stages. So what is wrong with that? What is cooked up about that? I'd like to understand that.
No, what he said was this. Find it. He said there's an unidentified sentinel event, the fetal heart rate drops, and then there's damage or injury.
Yes.
That is predicated on there's an assumption there, and the assumption is that before the unidentified sentinel event happens, you can pick up that there's something wrong. And we say that there's no such thing here.
That's not how I understand the argument, Mr. Breinders. He says there's a sentinel event, and then you pick up that there's the heart rate has dropped and it stays there, and then you got to really get going, and that fetal bradycardia can last up to 30 minutes, and thereafter the injury occurs because of the starvation of oxygenated blood to the brain.
And here's what the obstetricians say, or the experts on this point. At paragraph 7, page 597.
Yes.
They say it is doubtful whether it would be possible to perform a cesarean section quickly enough to prevent the neurological sequelae of an acute profound hypoxic event in this time interval. Now, what they're talking about there is the time interval they're talking about there is from the onset of the sudden drop in the fetal bradycardia to the time that you deliver the baby by cesarean section, and they don't contemplate any other emergency measure. There's no other emergency measure contemplated in the agreement between the obstetricians. The only measure they contemplate is a cesarean section. And what they say is that from the time that the fetal heart rate drops suddenly and you get the fetal bradycardia, from that time to the time that there's brain damage is not sufficient to do a cesarean section quickly enough to prevent brain damage.
Right,
and
sorry, you can just conclude, Mr. Breinders. Sorry.
Forgive me, Justice Ajit. I just wanted to say that that ties in with the evidence we already referred you to by Professor Kirsten, which is this takes between 10 and 30 minutes.
Yes. Well, I'm going to leave that there because I think it's on the record, the divergent views. I'd like to deal with one last aspect on the facts before I get to the law and some of the submissions you make. On the facts, why do you say that the concession on negligence was wrongly made? Here's the thing, we're dealing with a maternity ward that works according to maternity guidelines in a state hospital, and that's been accepted as the norm. Those maternity guidelines says on the onset of active labor, you must monitor every 30 minutes, and it wasn't done here. And it's been conceded, in my view, rightly so, that the norm, the reasonable norm imposed on midwives and on the nursing staff wasn't complied with, and therefore it fell short of the reasonable standard set out by the maternity guidelines. Why is there now an attempt to withdraw that concession? I don't understand that. It bothers me.
Well, can we just make this clear? And I think, Justice Majid, respectfully, we're all on the same page about this. Was the monitoring substandard in the sense that it did not comply with the maternal guidelines? The answer is yes, it was. And in that sense, they were negligent in their failure to comply with the maternal guidelines. But that's not the question. The question is, what measures were reasonably available to them that they should have taken in the case of an acute profound? Well, the measure available to them is a cesarean section. And the question is, did they fail to take that measure? Well, no, they didn't. A cesarean was ordered. The baby was delivered by normal vaginal delivery with an episiotomy within 25 minutes.
You see, Mr. Brenders, sorry, Mr. Brenders, I must just stop you there, if I may. You see, the experts made very clear that precisely because that sentinel event is so difficult to discern, it's and that hypoxia then occurs, it's absolutely imperative that you must monitor as prescribed, because otherwise you won't pick it up. And therein lies the negligence as alleged by the plaintiff and as conceded by the defendants at the trial. The negligence lies in the monitoring that didn't occur, which should have occurred to pick up this hypoxia.
It is not difficult to discern an unidentified sentinel event. He tells us what happens. In other words, you know when it's happened that it's happened. That's not the difficult part. The question is, when it does happen, is there something that the nursing staff can do in time to prevent brain damage? That's the question. And here, the only emergency measure available was contemplated by both obstetricians, was a cesarean section. That doesn't take 30 minutes. According to Dr. Pistorius, it takes longer than 30 minutes to get there. But that's not even the point. The point is, from the time they order a cesarean section, it takes less than 30 minutes to deliver the baby.
All right, I'm going to move on from that. I want you to take you up on something you said in your heads. In your heads at page 11, paragraph 39, you say the following. It follows then that the omission to monitor at 3:45 and 4:15, in other words, in that 1.5 period, does not establish causal negligence. Now, what I understand you to say, and then you say that negligence doesn't hang in the air, and you refer us to Premier Western Cape versus Fair Cape property at paragraph 41. I'm going to go to that passage now. But this is the point. We all know it's been established since Kruger versus Kutsia in the old AD already as many, many decades ago. A plaintiff and D-League must prove negligence, must prove wrongfulness, must place causation. What do you mean by causal negligence? Surely once negligence has been proved, for example, let's just for the moment take the negligence being the failure to monitor. The next question is, did did that failure, that neglect, that negligence, did that cause the damages suffered or the injury sustained and therefore the damages suffered? So that's the next step after negligence, because it seems to me you're conflating negligence and causation here by talking about causal negligence. If what is meant by that is that you have to prove causation, of course, we're on the same page then. But what do you mean by that?
Well, as I say, the question is, what emergency measures were reasonably available to hospital staff to prevent brain damage in the case of an acute profound? And did they fail to take those measures? The only measure contemplated here was a cesarean section. In fact, in their joint report, they don't talk about the measures short of a C-section. They talk about an emergency Caesar. That's the only measure you can take to prevent brain damage in the case of an acute profound. Now, it was ordered. Did they fail to perform a C-section? Well, they didn't need to because they delivered before the C-section could be performed. So they were negligent in failing to take measures to prevent the damage.
We're then moving in circles because that's exactly the answer you gave me before. All I wanted to understand is what is this causal negligence you talk about? Because all that Lewis J.A. says in Fair Cape Property, at paragraph 41, is that you can't have wrongfulness in the air. That is what she refers to an earlier judgment of Harms J.A. And all that Harms J.A. says that Lewis J.A. confirms is that you can't have wrongfulness in the air. And of course, that's right. Wrongfulness is a value judgment. In other words, what is wrongful, as Harms J.A. puts it, what is wrongful to one person in a certain context may not be wrongful as against another person in another context. Well, that's first principles. And certainly not with negligence. Once you find negligence, for example, the failure to monitor, that's not the end of the matter. You must then determine whether that negligence caused, but for that negligence, they would not have ensued the injury. If that's what you mean, then I understand. But otherwise, I don't understand what you mean by causative negligence in the context of the Fair Cape Property passage.
Justice Majid, I don't want to argue the Fair Cape. I want to come back to the facts of this case.
Now you cited it. I'm just asking you because you cited it.
Well, and I cited it for the principle, but the application of the principle in this case goes like this. So let's assume that they monitored. In other words, the but-for test. Let's assume they monitored and they picked it up before 4:45. You still couldn't do anything to prevent the brain damage because you couldn't perform the only emergency measure or the only reasonable emergency measure available to you within the time that it takes to brain damage from the onset of a sudden, an unidentified sudden sentinel event, I beg your pardon.
I see. I understand.
That's the problem here. In other words,
I understand.
Yeah.
And therefore, when the experts joint minutes say this event must have occurred between 3:15 and 4:45, that doesn't help us, you say?
No.
Because we must know when exactly it happened. And absent monitoring,
forgive me, Judge.
Absent monitoring, we don't know when it happened.
No. What they say is this: they say it happened between 3:15 and 4:45. They say even if you picked it up, you could not do something in time to prevent the brain damage because brain damage, according to Professor Kirsten, takes 10 to 30 minutes and the Caesar takes longer. And the Caesar is the only thing that saves the baby from brain damage. That's the problem with an acute profound.
Yes. I just want to, sorry, the last aspect is just the law, and I'll just be very brief about it. In Mashongwa, this court said that its decision in Lee did not purport to change the but-for test, as some commentators said and some academics wrote. It simply said that there are some instances where the but-for test does not really answer the questions. For example, Mr. Lee's case, he got TB in Polsmoor prison, and he was unable to pinpoint exactly the source, A, or the source of the infection, and B, the time when that infection occurred. So this court said one needs to be flexible, and Mashongwa explained that and said, and the clerk afterwards, said that you need to be flexible when you apply the but-for test. So it's not the one or the other. And I just want us to be very clear on that, because it's as if it's either you apply this test or the other test, but it's actually the same test with a measure of flexibility where the exigencies require you to look at, can you determine the source of the infection? Can you determine the exact hypoxia when it occurred, and so on? Do you accept that that is, or am I wrong, Mr. Brenders?
Well, we submit, Justice Majid, that Lee doesn't apply here because this is not a case where you don't know what the cause of the injury is. The cause of the injury is the unidentified sentinel event. That's the cause of the injury.
No, but I'm just asking, sorry, Mr. Brenders, I'm just asking, do you accept that that is the law? That is what the cases say.
Well, as our understanding of Mashongwa and of the Clerk is that Lee really has limited application, and it applies to those very limited, unusual cases where one can't tell between a number of causes
Mr. Brenders, please be still when you move like that. I think it affects. I want to concentrate on your argument, but when you move like that, it disturbs that.
Apologies.
Yes. Continue.
As we understand the Mashongwa and de Klerk, what they say is, what this court has said is that Lee has application in limited circumstances, and that's where you have an unusual situation where the cause, what materially contributes to the injury, can't be determined with certainty. There's more than one potential cause. And here, that's not the case at all. We know what the cause is here. So Lee wouldn't apply here. And that's our understanding, Justice Majid, of the application of the causation test.
Thank you. Thank you, Mr. Brenders. Thank you, ACJ.
Mr. Brenders, if I may follow up.
One second. Mr. Brenders, the measures that I think I referred to as preparatory or measures earlier on, which would buy time. On your argument, are you saying they were not applicable in this case?
Yes.
That is. I think putting the mother to let the mother lie on the left side and other measures that were taken. Are you saying they were not applicable in this case? They could not be resorted to, because as I understand the evidence, such measures could enable the baby to delay, or that those measures could delay the point until the cesarean action is undertaken. Maybe not all the time, but that delay could be helpful. Are you saying that on the facts of this case, those would not be applicable?
Yes, because it doesn't matter where you have an acute profound, which is the total cutoff, near total cutoff of the blood supply. Doesn't matter how much oxygen you give the mother, blood isn't getting to the fetus. That's the problem. Those measures are measures designed to resuscitate the mother, and that then bolsters, it improves her blood supply, it improves the oxygenation of the blood supply. And if there is a blood supply to the fetus, that bolsters the well-being of the fetus. So it helps the fetal heart rate to rise. But there we are talking in the context of a partial prolonged. In other words, you're talking, it's what Professor Kirsten says, where you have the intermittent occlusion. So you get a total occlusion, but it relaxes, and then you get an occlusion and relaxes. In that situation, of course, those measures would help. But here you had the total occlusion, according to Professor Kirsten, of the blood supply to the fetus for 10 to 30 minutes.
But was it put to the experts that those preparatory measures would not be applicable in this case?
Well, Justice, it's clear that if all of us had had that case, we would have put that to the experts. But what I'm submitting is that when you look at the context in which these experts talk about resuscitation measures, the context is in a partial prolonged situation. In other words, it is in a situation where there are already warning signs, meconium-stained liquor, fetal distress, where there are already those signs, and then you can pick up that something is going on, but that's a partial prolonged picture and you don't have it here. Both of them say that you don't have it here. It's what you would expect to see if you have some deprivation of the blood supply to the fetus, but that's not what you have here. Once you accept that there was an acute profound insult to the fetal brain, then the court must live with the consequences of that. And that is that the obstetricians say you can't do a cesarean in time to prevent brain damage.
Of course, if your answer is that the context in which that evidence about preparatory measures was given did not give rise to an obligation on the part of counsel for the respondents to put this to the witnesses, it's one thing. But if the position is that counsel for the respondents was supposed to put that to the witnesses and did not do so, isn't the position that the law would be that the respondents can't rely on that because it would be unfair on the witnesses who were not given a chance to deal with that issue?
Well, we submit that if you look at the reports which the experts confirm, together with the evidence and the context in which they talk of resuscitation measures, you can, on a conspectus of all that evidence, you can make conclusions. And those conclusions are that when we talk about resuscitation measures, they apply in a different scenario. They don't apply in an acute profound scenario.
Yes, thank you. Justice Taron?
Thank you, Acting Chief Justice. I was in fact going directly to the point that you had raised, Acting Chief Justice. Mr. Brainders, at paragraph 18 of the full bench judgment, which we find at volume 10, page 947. It says, once the trial court had found that the lack of fetal heart rate monitoring between 3:15 and 4:45 was essential for purposes of detecting signs of possible hypoxia amounted to negligence, the question becomes whether, had there been adequate monitoring, warning signs would have been picked up and that there was then enough time to engage proper emergency measures which would have avoided brain injury. This being the very question in many cases, including in AN referred to above. By emergency measures, we take it to mean performance of cesarean section. Now, the full bench appears to accept that the only emergency measure available was a cesarean section. But I'm not sure that that accords with the evidence. And that is why I also have some difficulty with your argument. If one looks at the evidence of Dr. Kirsten in volume 2 at page 135, at line 12, there is reference to an obvious catastrophic event. That would be the centennial event. Line 17, it says, goes on to say, so he's talking about the sentinel event. It is out of the blue. A baby will start have fetal heart rate abnormalities, complete normal fetus, and which could then be changed into severe bradycardia. And if the fetus is not delivered, the fetus could die, or if delivered too late, could have cerebral palsy. But, and this is the important part, if it is possible to start with resuscitation, so to first start with resuscitation, and deliver the fetus, expedite the delivery, you can hopefully prevent hypoxia or brain damage. So in Dr. Kirsten's evidence, there's measures to prevent brain damage once the sentinel event occurs.
But this was, and I think that Justice Rogers referred to this in a passage later on, where he says, look, I'm not the obstetrician. You must leave that to the obstetricians. But what he says there, that you could take measures, so measures short of an emergency Caesar. Now remember, in this case, the obstetricians agree.
I'm sorry to interrupt you. They agree there must be a seizure, but there can be measures taken before the seizure to possibly delay the onset of brain damage.
No, they don't agree that. They don't say that in their report at all. We're talking about the joint minute. Sorry, not report, the joint minute. In the joint minute.
Mr. Brainders, my question is premised on the evidence of Dr. Kirsten, which I have just referred to you at page 135. And I would appreciate if you can respond to my question, having regard to his evidence, please.
It's illogical. He says, if you don't get the baby out, it'll die. And he says that in more than one place. So this idea, in other words, the only thing that saves the baby from brain damage is a Caesar. You've got to get it out there because, and you can see why. I mean, we don't need to be experts.
We're on the same page regarding the seizure. I had understood Dr. Kirsten's evidence to say there were measures you can take before the seizure, before you perform the seizure. He's not saying you can avoid the seizure. He's saying there's measures you can take once you realize that the sentinel event has occurred. You can possibly prevent brain damage. That is what I'm asked. That's the evidence I'm asking you to respond to, Mr. Brainders. Your initial response was his evidence is illogical. At no stage can I recall it being put to Dr. Kirsten that this evidence he gave was illogical.
Now, my initial response was he's not an obstetrician. So he's not the person who can tell you whether there are other measures that could be taken to save the baby. That's not his job. And in fact, he says that later on. He says, as regards those measures, you've got to talk to the obstetricians. When the only obstetrician the obstetricians in their minute don't talk about any measures other than a Caesar. There's no...
Was Dr. Kirsten ever challenged on this evidence that he gave?
But he says, I'm not an obstetrician.
My question, Mr. Brainers, was Mr. Kirsten ever challenged on this evidence that he gave?
It doesn't matter. He wasn't, but it doesn't matter. He's not an obstetrician. And he says, I'm not. And I can't tell you, I'm not. It's not my job to talk to you about resuscitation of the baby.
Mr. Brainders, I guess your answer is that he was not challenged.
No, he wasn't. I've said that.
Yes, no, that's what Justice Theron wanted to hear. Then if you wanted to advance whatever, then at least you would answer the question directly. He wasn't challenged, but you say the fact that he wasn't challenged doesn't give rise to any problem for your case because he was not an obstetrician. That's what you say.
Correct.
And then just finally, Mr. Brainers, if on the same aspect, if I can take you to volume 3, page 205. The evidence of Dr. Pistorius, line 22.
What's the page number?
It's 205, Acting Chief Justice, of volume 3.
Thank you. And it's
And
line 22.
Line 22, my lady, if the intrauterine resuscitation had been done, it could have improved the outcome. And which is, of course, we cannot say in an individual case whether that would be sufficient to improve the oxygenation of the baby.
Yeah.
And Dr. Pistorius' evidence, to some extent, corroborates the passage of Dr. Kirsten's evidence that I referred you to a few minutes ago. What is your comment on that?
Well, this evidence is speculative. He says it could have. He doesn't know whether it could. He said it's speculative, one, but two, more importantly, I've referred you to the passage later on where he deals with this in more detail. In other words, the resuscitation measures. And I illustrated to you with reference to that passage that what he's talking, when he talks about resuscitation, he's really talking about a partial prolonged situation here. He's not talking about an acute profound. So when he says it could have, well, as my lady's already made that point earlier to Mr. Budlander, where does that take us? And we know that the obstetricians say there's only one emergency measure you can take here. They've already agreed on this. They don't agree that there are other things you can do. They say you've got to go to a Caesar, and you can see why. Because you've got to remove the baby or the fetus out of a situation which is life-threatening. There's no other way to save it. You've got to get it out there because it's not getting any oxygen.
And then if we go over the page at page 206, the court said, yeah, you cannot say it would have, but you can say it could have. And then he responds, it could have. And then Mr. Stradum then puts to him, and if one successfully implements those actions, can one buy time, so to speak?
Yes.
And Dr. Pistorius says, yes, certainly. And then he's asked, what would the benefit of that be in this context? And I would understand context to be also the context of the matter that they were dealing with. The benefit of buying time is that the half an hour ideal time to decision to delivery is difficult to achieve in practice. And the intrauterine resuscitation buys time to keep the baby relatively safe until the time the cesarean section can be done.
Yes, now I've referred you to the cross-examination where that is taken up by Mr. Soni at volume 3, page 205 to 6. And there we can see that when he talks about resuscitation, he's talking about it in a different context. It's in the context of a partial prolonged.
Thank you, Acting Chief Justice.
Thank you. It looks like there are no further questions from my colleagues. We are at...
Sorry, SCJ, I do have some questions.
Yes, Justice Matondo. Yes.
Thank you, SCJ. Mr. Brenders, Professor Kirsten, in volume 2, page 133, he says that fetal rate monitoring and frequent observation can give one an indication that climbing up on the insert. You see that, I'm just paraphrasing what he says there.
So page, Justice?
Page 133, lines 6 to 8.
Volume 2,
Volume 2, yeah.
Yes, I got that. Thank you, Justice.
You see that?
Yes.
So what do you understand about climbing up?
There isn't such a thing because look at page 135, lines from about 16 onwards. He says, this condition described by Pascal, which is called an unidentified sentinel event, it is out of the blue. It's not something
I
that keeps
understand
you.
Well, at some stage is dealing with or talking about two scenarios. But in this scenario, I want to know your understanding of climbing up.
No, we say there's no
what
climbing up.
meaning
In fact,
do you attribute to that?
no, we say there's no climbing up. If you look at page 135, he says an unidentified.
No.
Mr. Brandes, you're not
Sorry.
understanding. You're not understanding Justice.
Brandes.
Sorry, Justice Matondo. Mr. Brandes, you're not understanding Justice Matondo's question. You are saying there was no climbing up. He's not asking whether there was or there wasn't. He's asking what your understanding is of what the witness is talking about when he talks about climbing up.
Well,
Thank you.
Well, he can't be talking about an unidentified sentinel event because he's told us later on, he's described how that happens.
No, but Mr. Brandes is talking about it at page 135 I referred to. He's talking about it.
Yes, but at page 135, he says.
Yes, 135, lines 6 to 8, where he talks about monitoring and observation. In fact,
I'm
he's
sorry,
telling
Justice Madondo. I think you mean to refer to page 133, Justice Madondo, line 6 to 8. I'm
sorry, 133. Thank you, 133.
Correct. So you got to, he says, fetal frequent observations are important because it will give you an indication that climbing up the onset. But he says at 135. Yeah. But he says
sorry, don't refer me to 135. At 133, he says that can give indication of climbing up. My question, what do you understand by that?
It doesn't, well, I've got to look at his evidence as a whole. I can't take, as I say, lines. I've got to look at the evidence as a whole. One can't just take certain passages. I accept that, goes for all of us. But when he talks about the literature in particular, he says that this is something that comes out of the blue. That's why it's called a sentinel event. It is a sudden, it is an unidentified sentinel event is the sudden onset of fetal bradycardia. He says that in his report. It is the sudden onset of fetal bradycardia. So there's no, if you look at his evidence as a whole, this notion of climbing up, in other words, that you can climb up and get to an acute profound sentinel event, well, that it doesn't square with his evidence as a whole.
Mr. Brandes, I'll take it that you don't have an answer to this question.
Oh no, I've answered it.
Okay, let me move on. Is it not this suggestive of the fact that there is a process before the bradycardia sets in?
Well, that doesn't square with his report that an unidentified sentinel event presents by a sudden severe fetal bradycardia that persists. That's what he said in his report.
If it talks, oh, sorry.
There's no, this is not something that you can see is going to happen. It's not the way it works. I mean, you're monitoring every 30 minutes. If it happens between monitoring, you'll pick it up after it's happened and you monitor, you'll pick it up. Of course, we accept that. But it's not something you can see coming and take precautions against because you don't know it's coming. It's the sudden onset. It's out of the blue.
Well, if you marry the two, the climbing up and the setting in of bradycardia.
With his report.
Doesn't make sense.
If you look at his report.
Mr. Brandes, let Justice Matondo finish his question. Justice Matondo, finish your question.
Thank you, CJ. Mr. Branders, if you put the two together, the climbing up and the setting in of bradycardia, doesn't tell you that there is a process before the setting in of the bradycardia from indication.
No, it doesn't, because when he talks about the sudden onset of fetal bradycardia in his report, he refers there to the literature. And in fact, he also refers in his evidence to Passana, the literature, and he says that this thing happens out of the blue. So if you compare what he says at different points in his report and in the evidence and what he says about when he invokes the literature to support him, if you take all of that together, what we're talking about is not something that you can see coming. That's not the case here.
Yes, the last question I want to put to ask you or put to you, the plaintiff testified that at some stage, one of the nursing staff applied some pressure to her abdomen, forcing her to give birth to the baby. Could that not be also the cause of the injury to the unborn baby?
No, that's what neither of the courts find that was the case. But this is really important about that allegation by the mother. If you look at the records, you'll see there was one sister who delivered this baby, one sister. She delivered the baby between 4:45 and 5:10 by performing an episiotomy, which is a procedure you would perform on the mother. Well, a midwife delivering a baby in this sort of situation, clearly it's an emergency, clearly it's urgent. She's performing an episiotomy. I don't think she has time to put her palms on a bedside table, never mind the mother. I mean, it's just far-fetched. It doesn't square with the objective facts.
So what are you querying is her testimony or whether that could have happened or not?
Evidence. I'm
not clear now.
No, there's no evidence about fundal pressure. The mother, in I think it was a questionnaire, which she filled in.
There is evidence at volume 4, page 344, lines 22 to 25. Volume 4 of the record.
Well,
page 344.
But two things. This doesn't square with the objective evidence. I mean,
I'm sorry, Mr. Brenders. I'm sorry. What's the line, Justice Matondo, where we find it at page 344?
Well, start from line 22 to 25.
Okay. Yes.
Where she says.
Yes, continue, Justice Matondo.
Where she says the other sister came to me and she took something like a blanket, hospital blanket. She put it over my breast. Then she pushed very hard. Then the baby came out.
Well, two things. The first is that doesn't square with the objective evidence where you had one sister performing an episiotomy on this mother to get the baby out. That's the first. And the second is this. The cause of the brain injury was not fundal pressure. The cause of the brain injury was the unidentified sentinel event about which the hospital could not do something quickly enough to get the baby out. I could not perform a cesarean section. This isn't the case where the allegation is on the objective evidence. You can't make an allegation that the injury was caused because somebody pressed on the mother's abdomen. If you look at the evidence by the experts, they accept that this was an acute profound.
Well, okay, but I'm saying that regard being had on the fact that there was evidence that the baby's head was too big for her pelvis. If pressed hard in the manner she explained, could it not cause any problem to the baby?
No, because Dr. Pistorius actually, let me see if I can find that. He deals with that and he says, CPD was not a problem here because the baby was delivered so quickly. If this was a case of CPD, in other words, cephalopelvic disproportion, where the head is too large to pass through the birth canal, then you wouldn't have had a birth as quickly. And he deals with that. Forgive me, give me a moment. In his examination in chief at volume 2, page 184. He said, despite the caput and molding here, the head passed through the birth canal fairly quickly. So that wasn't the problem. And that's why, objectively, it just makes no sense that this was a case where the baby was forced out because somebody pressed on her abdomen.
You done, Justice Madondo?
Yeah, thank you, ACJ.
ACJ, can I just raise one issue?
Yes.
Counsel? It's just to tie up a loose end, Mr. Brainders, and it is related to the question of the fundal pressure. As I understand the trial court's judgment, towards the end, this is at paragraph 28 and following, volume 9, page 904. You don't have to go there. The trial court considered a separate claim by the plaintiff in her personal capacity, essentially for assault. That's technically how the law would qualify it. The fundal pressure was contrary to medical standards. It caused her pain. And although the damages have not been quantified, it was held that the defendants were liable to the plaintiff in her personal capacity. You'll see in paragraph 28, they say the issue of the fundal pressure is not material to the child's injuries. However, as the plaintiff has claimed in her personal capacity for damages, I need to resolve it. The judge goes through the evidence, and towards the foot of the page, she says the plaintiff was a good witness on this aspect. This was the nurse's alleged conduct. It would have, and then about line 10 over the page at 905, I find that Victor was born vaginally as a result of one of the nursing staff applying fundal pressure. All the experts agree this procedure is not sanctioned. And the last sentence, the nursing's conduct, sister's conduct was clearly unlawful. And then in paragraph 34, the order includes that the second defendant is liable to the plaintiff both in her personal and her representative capacity for damages to be assessed. Am I right in understanding the trial court's finding in regard to the plaintiff personally on fundal pressure effectively to have amounted to a finding of assault, and she is entitled to damages?
Yes, that didn't relate to the to the injury to the minor.
The full court seems to have set aside all the orders of the High Court, treating the plaintiff's personal damages as if they all flowed from the hospital's culpability in respect of the child. You know, it's the burdens which having to care for a cerebral palsy child placed on the mother. But it seems to me this one stands independently, does it not? The fundal pressure assault stands independently of any findings to do with the child's injuries.
Yes.
And so whatever other order we make, is that an issue in this case, or can that order stand?
Well, it was set aside.
Well, it was set aside by the full court, yes.
The court, yes.
And you are now here on appeal, seeking leave to appeal against the full court. And the question is, whatever we decide in respect of the child's injuries, what do we do with this finding, if anything?
Well, there's no objective evidence that there was fundal pressure. I know the mother says that there was.
Well, and the court made a credibility finding. It said they found her a good witness. Right.
Yes, but that's true, but the starting point isn't is somebody a good witness. The starting point is what do the records show? What objectively do the records show? Now, the records don't show that fundal pressure was applied. They show that there was an episiotomy. They show that there was one midwife who performed the episiotomy. I know that wasn't put to the mother, but it seems unlikely that in a situation where you're delivering within 25 minutes by performing an episiotomy, that why would you want to apply fundal pressure to the mother's abdomen?
But is the bottom line, in answer to my question, you ask us to reverse the trial court's factual finding on that?
Yeah, to uphold the full bench on that, yes. Yeah.
Thank you.
Is for the respondent, Justice Rogers. So he's happy with what the full court did.
No, I appreciate that.
Okay, all right. I think we are done. I think my colleagues are done with questions. We are at 1:02. Mr. Brainders, I take it that you are done as well.
I have.
Yes. Okay. I think I'll allow Mr. Patlender to respond 15 minutes, and then we will adjourn after that. Mr. Patlender.
Thank you, Acting Chief Justice. Acting Chief Justice, we've listened carefully to the debate between yourself and your colleagues and our learned friend, and there are 5 issues we wish to deal briefly with in reply. First, very briefly, the volte-face on negligence. Second, and more importantly, the correct question to be asked in dealing with causation. And then 3 forms of confusion with respect that our learned friend's argument demonstrated. The first is the confusion about what Professor Kirsten actually said in his report. The second is the conceptual confusion about what happens in a situation like this. And the third is the confusion about what was in the evidence and what was put and not put. If I could deal with
Mr. Butler, sorry, is one of the 5 going to touch upon the point that Mr. Brainders very forcefully made, is that when we talk about measures, preparatory measures, as the ACJ called it, or buying time, as it was called in the trial, that only applies to a partial prolonged event, insult, or as opposed to an acute, profound insult, as was the case here. If it's not one of the 5, please, for my benefit, would you address that one?
It is in fact the 4th, Justice Majid. It is the conceptual confusion that my learned friend appears to be laboring under, and I will deal with it right there. Thank you. So, Acting Chief Justice, the first is the question of negligence. I can be very brief. With great respect, I still do not understand what the respondent's case is on negligence, and I still do not understand on what basis the respondent purports to contest it. It's common cause that the guidelines required monitoring every half hour. It's common cause that they didn't happen. There is no explanation for that, and negligence, I respectfully submit, has been established. That means we can move past negligence, as the trial court did and as the full bench did, onto the question of causation. And the question, but we need to spend a moment on what the question is, because our learned friend began by saying the question is, was the conduct of the respondent the cause of this event? Was the conduct of the department and its employees the cause of the cerebral palsy birth? Now, that, of course, is with respect the wrong way of framing the question, because, of course, nobody is suggesting that something happened in the sense that someone suffocated the child themselves or that someone did something proactive to cause it. The real question, of course, is whether the respondents adhered to their duties to monitor. We know they didn't. And whether they adhered to their duties to monitor, pick up the problem, and treat the problem. And we submit they didn't. And the question is, was that the cause, legally speaking, of this event? So it's self-evidently no good to say, well, we didn't cause this, these things just happened. The question is, did the respondents adhere to their duties to monitor, pick up, and treat the problem? And Justice Chiki's questions on that score were very helpful with respect. Because if they were meant to monitor every 30 minutes, which they were, and if they didn't do so, which they didn't, that prevented them from engaging in the necessary measures to allow the cesarean section to occur. Now, my learned friend, Mr. Brander, says, but they did do a Caesar. They were trying to do a Caesar, and the baby was delivered. Well, yes, of course, with respect, because the process started at 4:45 instead of at 3:30 or 3:15 or 3 o'clock or 2:45. So when you start the process too late, because you were not monitoring and picking it up, self-evidently you can't complete the Caesar, and you can't complete the Caesar because you started the process too late. So to say, with respect, somewhat glibly, well, they tried to do a Caesar and they couldn't manage, therefore there's no blame, with respect, is to answer the wrong question.
Well, Mr. Butlander, I'm sorry. Actually, you do remind me, I had wanted to ask Mr. Brenders at some stage.
Yes.
Whether there is any evidence that suggests that if they had monitored the situation the way they were required to, whether there's any evidence that suggests that they would not have picked this up earlier, namely what they picked up at 4:45. Because yes, if the position is that they could have or would have picked it up earlier, and you mentioned 3:30, it may well have given them more time for this, even the cesarean section. What is the position about the evidence in regard to that?
I'm unaware of any such evidence.
Yeah. Okay. Continue.
Thank you. Thank you, Acting Chief Justice. So the question is, did they monitor? We know they didn't. If they had monitored, would they have picked up warning signs? And would the warning signs have allowed them to buy the time for the Caesar? Now, Justice Theron put a question to me quite fairly and said, well, what is the evidence on that score? And I took Justice Theron to page 135, the evidence of Professor Kirsten. It's 135 lines 20 to the end of the page, which said, if it is possible to start with resuscitation and deliver the fetus, expedite the delivery, you can hopefully prevent hypoxial brain damage, sometimes not completely, but you can at least make a difference in the long-term neurodevelopmental outcome. Now, when that was put to my learned friend, Mr. Brandis, his answer was, well, that is illogical. Well, with respect, I don't understand why it's illogical. I'm going to demonstrate to you that, in fact, it's that his criticism of it being illogical is based on his own conceptual confusion about the difference between the event and the injury, which I'll come to. But more importantly, it was never put to the witness that it's illogical. It was never put to the witness that that conclusion is illogical. But you don't have to content yourself with Professor Kirsten, because in answer to Justice Theron's question, what I must also refer to is what appears in Dr. Pistorius's report, which is at volume 5, page 467. This is the second report from Dr. Pistorius. It's volume 5, page 467, the last two paragraphs of the report, where Dr. Pistorius says, there was clearly insufficient monitoring during the latent and active phase of labor. No sentinel event was recorded, but a sentinel event would easily have escaped notice given the insufficient monitoring. The available evidence indicates that there was suboptimal care during labor, resulting in fetal asphyxia and subsequent hypoxic ischemic encephalopathy, which would have been avoided by appropriate monitoring and action. So Justice Theron, when I said to you there was no evidence that it would have been avoided, I overstated it somewhat. There is such evidence contained in this report, which of course is confirmed in the evidence. And again, this was not challenged. So when we look at the question, could they have made a difference? The answer self-evidently is yes. And we submit on the evidence, it would have made a difference. But how then does my learned friend persist in contending that causation is not satisfied? It is, we submit, by confusing three questions. The first one is perhaps the most glaring. Our learned friend said again and again and again that this was a case of a sudden event, and that because it was a sudden event, there was no warning sign, and therefore it could not have been prevented. And he referred again and again and again to the report of Professor Kirsten on this score. That is his evidentiary basis for saying that. But when you actually go and read what Professor Kirsten says in that very passage, it is to exactly the opposite effect. Could I ask the court to have regard to volume 5, page 425, where Professor Kirsten's report appears? If the court has regard to line 7, which is the fifth bullet, Professor Kirsten is explaining what can cause acute near total hypoxia. And one of them he gives, and that's the relevant one, he excludes prolapsed cord, maternal shock, ruptured uterus, tight nuchal cord, etc. And he says, unidentified sentinel event. And he then says, sudden onset fetal distress on CTG. That's the reference to sudden. So does the court have the page? I beg your pardon, I should just check.
You said 425, line 7.
425, line 7.
Yes,
because if there's anything, if there's a single page to read in light of my learned friend, Mr. Brandes' argument, this is it. Because in the bullet, this is the reference that my learned friend relies on, to sudden onset fetal distress.
Oh, yes.
And what it says is as follows, Acting Chief Justice. It says, sudden onset fetal distress on CTG and eventually bradycardia. Just let me pause there. That alone makes the point. First, there is fetal distress on CTG, sudden onset, and then eventually there is bradycardia. And of course, we know that the bradycardia is the 10 to 30 minutes. So sudden onset fetal distress on CTG and eventually bradycardia can occur in the absence of an obvious sentinel event during labor, so that often the exact cause of the severe fetal hypoxia remains undetermined. In other words, it's an indeterminate sentinel event. And then there's a reference to Pasternak. And then it says, however, appropriate fetal rate monitoring during the labor will identify a sudden onset fetal bradycardia so that appropriate measures such as the fetal resuscitation or expedited delivery can be instituted. So in the very passage which my learned friend relies on about sudden developments, it is said, appropriate fetal heart rate monitoring during labor will identify a sudden onset fetal bradycardia so that appropriate measures such as fetal resuscitation or expedited delivery can be instituted. And then it says about this case, again, Professor Kirsten, the midwife should have recorded Victor's fetal heart rate half-hourly during the active phase of labor. She should have informed the attending obstetrics doctor that there was meconium-stained amniotic fluid. The doctor needed to assess whether delivery had to be expedited. It is my opinion that a sentinel event probably took place and that due to suboptimal intrapartum monitoring, it was not identified and acted upon. Now, with respect, what is left of the proposition at the centerpiece of my learned friend's argument that because it was sudden, there was nothing you can do? The very passage he relies on says exactly the opposite. So that is the first confusion, and with respect, it is fatal. The second confusion, and this relates to the question Justice Majid posed to me, is the confusion about, it's a conceptual confusion, and it's a confusion between the time and nature of the sentinel event on the one hand, and the time and nature of the injury on the other. So the sentinel event can be identified or unidentified. So if it's identified, for example, it can be the abruption where the placenta detaches, or it can be the prolapsed cord, or it can be unidentified, exactly as the passage I've just read. In other words, it's not apparent exactly what causes it. And obviously, depending on which of those occurs, it can have a different effect. So when there is the suggestion of a total occlusion of oxygen, for example, immediately arising, that might be the case where there is an abruption because the placenta detaches, there's immediately no oxygen, and that's it. It's different when the sentinel event is the kind of event being described here, which is not, there's no obvious cause for it. It is simply results from the general labor process, the constant contractions, the repeated contractions, and that produces a different form of result. But the important point is that's about the sentinel event. That sentinel event, that's what I call the first stage, then produces the second stage, which is the injury. And it is the injury which is the acute, it's the acute injury, as opposed to, for example, a prolonged injury. It depends. So the point is that what my learned friend has done is he's conflated the event with the injury, and they can't be conflated. And so it's all very well, with great respect, to take you to the joint minute again and again, and to say that the experts agreed at paragraph 5 that there was an acute, profound hypoxic event. That's correct. But what they're speaking of there is the injury. And so, with respect, it doesn't answer the question at all as to whether it was possible to take measures to prevent it. What answers that question is the passage I've already taken you to and the evidence that is given. And let me say, the experts, the same two experts, Kirsten and Pistorius, whose evidence I've taken you to, were acutely aware that what was going on here was an acute injury. They didn't think it was prolonged. And that appears from the evidence. I'll just give you some of the references without taking you there. But if you have a look, for example, at the report of Kirsten at page 423, line 21 and following. If you have a look at Kirsten at page 425, that's the passage I've already taken you to. If you have a look at Kirsten's evidence at page 133, line 13 to page 134, line 11. And if you have a look at Pistorius, page 206, line 3 and following, you will see that there they are acutely aware of the fact that this is an acute event, and yet they consistently say you could have bought time. Their version was you could engage in measures to buy the time, even though this was an acute event. And the reason that is so is because they don't confuse or conflate the two stages. So they accept it was an acute injury, but they don't confuse and conflate those two stages. And so,
sorry, Mr. Butlander, just to go back, when you started out, you spoke about a 3-stage process.
Yes.
Am I right that the two that you've mentioned interposed would be the fetal bradycardia, because yes, the sentinel event causes a starve of flow of oxygen, of oxygen. And the heart rate slows down to the extent that there's bradycardia for a prolonged period, and we refer to that fetal bradycardia as below 100 for a substantial time. It doesn't go back up.
Yes. In other words, there's the sentinel event, and that will produce warning signs, and the warning sign will be the dip in the heart rate. It might not even be below 100. It just might be a dip and slow recovery. So it's the irregular heart rate. It might not be below 100, and it certainly might not stay below 100. So it's the sentinel event, that's stage 1, then the warning signs, then the injury, which is the acute injury, and the injury is the fetal bradycardia proper. That's the evidence that was given, and then the brain damage. And so with respect, it's true that they didn't explain it as neatly as I've sought to as the 3 stages, but the evidence is only consistent with that because they didn't conflate the event and the injury, quite the contrary. Lastly, there is the evidentiary confusion, because what our learned friend does is he refers to the evidence by pulling out one line or two lines from Professor Kirsten's report. The two lines are firstly the line about the 10 to 30 minutes, and secondly, the line about the sudden onset. And he treats those as dispositive by using them together with paragraph 7 of the joint minute, which didn't even involve Professor Kirsten. Professor Kirsten wasn't in the joint minute, of course. That was Dr. Cole for the defendant and Dr. Pistorius. So what he does is he pulls out those two lines from Professor Kirsten's report, and he pulls out the one line from paragraph 5 of the joint expert report, and then he pulls out a second line, which is paragraph 7, which I've already dealt with at great length, and I'm not going to repeat. And he puts those all together, and he reaches the conclusion, well, on the evidence, you must conclude that there was nothing that could be done. But there are two problems with that, and that's the last point I make. Firstly, it doesn't view that in the context of the evidence as a whole. You've got to read what was said in those reports in the context of the reports as a whole. You've got to read what the evidence as a context of the whole. You can't just cherry pick with respect. And secondly, he was driven to concede that none of this was ever put to the experts. In answer to the question of whether it was put, the answer was, well, I'm sure if any of us were arguing the case, it would have been put. Well, maybe it would have, maybe it wouldn't. But the bottom line is, in the absence of that being put, there was no basis to disbelieve the experts or reject their testimony, because it was simply never put to them. And you can't say that an expert's view is illogical or contradictory and forced to be rejected without having put that to the expert, and it wasn't done. So for all of those reasons, with respect, we submit that causation has been established and the appeal falls to be upheld on that basis.
Thank you, Mr. Patlander. I take it there are no further questions from my colleagues. Thank you very much. We reserve judgment and we adjourn. The court adjourns.
As the court pleases.
Today's proceedings have concluded. The host will now terminate the meeting.
Do I just go to leave? Okay.